Good morning, everyone. My name is Dinewas Kosana from Society Work and Politics Institute that is based
Recording in progress.
I'd like to welcome everyone to the third day of the Land Conference. I will give about 5 to 10 minutes of a recap, and we can perhaps shift to respective venues to see whether there are any maybe comments following yesterday's proceedings. Without wasting any time, I'd like to ask you to please mute yourselves and switch off the cameras and just to ensure that you do not interject with our audio. Just to go to our program, yesterday we started with the keynote address from Professor Mamdani, whose reflection of South Africa's experience of indirect rule via a comparative light shows that our experience under colonialism and apartheid in many ways reflects what was also done elsewhere. And he argued that the colonial regimes weaponized ethnic identities, making them, to be fixed entities. And he also went on to actually problematize the notion of community, of custom and customary law, suggesting that these were also weaponized by the colonial and apartheid administration to segregate communities. And so following that insightful keynote address, we also moved on to the third plenary that focused on organizing against the Bantustan mentality or the realities of communities in the Bantustans. And this specific session was chaired by Usis Constance Mkhali, who's the National Coordinator of the Alliance for Rural Democracy. And in the plenary, activists and organizers from rural communities presented their struggles, particularly also speaking to issues around resistance in the Northwest Province, in the Mpumalanga Province, in KZN, and in the Eastern Cape. And these are struggles to defend and reassert land rights, to demand accountability from chiefs and protection from the state, and participation in decision making, particularly around issues that affects them. So quite a lot was said about issues pertaining to lack of consultation in all the various provinces. And these are struggles waged against traditional corporate and state institutions and the individuals that represent them. And some of the activists raised concerns about the looming violence in the struggle against extractivism. And it was interesting. I think we were struck by some of the comments that were coming from the different venues in the provinces. In particular, one activist said, "Tina asisalali ngisho emakhaya siyasabiswa." And I think she wasn't capturing just her experience, but just how much of fear is instilled in communities, particularly who live in mining affected areas. And this fear is instilled by the police, by the chief, but also by mining companies themselves. And so these are the conditions under which they find themselves. And there was quite a lot that was said during the Q&A session, but I don't think we'll have enough time to actually go through all of that from the different venues. But another speaker said something very thought-provoking in the different venues that we've had, and she said there needs to be clarity about whether communities are overall against extractivism or they want mining done differently? And I think this is a very important question that I think communities have to think about, particularly even activists, going forward. And the session was followed by breakout sessions. We've had 2 of these, and the first looked at comparative African experiences with formalization of land tenure, looking at civil society organizations from Uganda, Malawi, and Mozambique, Zambia, as well as Zimbabwe. And while the second panel focused on understanding customary land rights by providing historical interpretations and linking these to the current struggle. Now, the last panel looked at the challenge of legislating customary law, whereas the last focus on the relationship between mobilizing and litigation. And again, there were a very thought-provoking question and comments from the different venues. And I think one specifically, I think that will get us thinking, particularly about today's closing session, was a comment which was made, which was that these conferences are great, but how do we take these to the people on the ground to help them mobilize? And I think that's a question that I think is asking us to really think forward about strategies, particularly going into today's closing. And with that said, really, I would like to perhaps open it up to the floor, and for us maybe in the different venues to maybe somehow give you a chance to reflect on what was discussed yesterday, and your reflections, your comments, and perhaps thinking through about how we move forward. And so I'd like perhaps to take comments as in reflection of yesterday's program from each venue, and then we can move on to the next plenary, and that will be the 4th plenary for the day. So may I please that we perhaps go on into the different venues and have a reflection, perhaps a single reflection on each venue before we move on to the next session. Should we start with Johannesburg, which we've always had?
Okay. Aki check-in le lena ne gore mgerere robetse king se leng gore mo tlhaloganya.
For those online, please, you're welcome to share your reflections on our chat box.
Yeah. Once again, I'm Malatse from. Once again, I'm Malatse from Macau. The speaker has just indicated that some communities want to know whether mining should not happen or whether mining should be done differently. I think the same thing applies to traditional leadership. It's going to take some time to do away with traditional leadership. And the calls for doing away with the traditional leadership are based on real atrocities. I agree with it. But in the meantime, it's going to take some time to do away with traditional leadership because it is entrenched in legislation. The other approach would be, can't we come up with a sort of a model like we did with customary law and common law, that three ways were suggested. The first one was fusion of the two. The second one, if I remember well, was there was amalgamation, and there's the third one. I've written the notes there. But can't we get something like that, amalgamation, or of ideas emanating from this conference? Let me tell you that other people like myself, I come from a royal family, and in 2 years' time or so, I might be elected into the traditional council. And we're going on the 24th of August, the next week, Thursday, we're going to Mabatho High Court to contest the traditional leadership. If we win, I'm also here, but I'm going to be a very important, in fact, I'm going to be in the traditional council itself and advise the COSI. But in the meantime, I'm going to need structures like this, the ideas that emanate from this conference, to show that traditional leadership, being as cruel as it is, it can be turned around. Ne? It can be turned around, and with amalgamation, ne? And ideas from here, that we can do something better in the meantime. My point is, it is going to take some time to do away with legislation for that. Yeah. And we are going to need your ideas, your inputs, your strength, to show us how we can go forward. Because, you see, I'm born in that family. There's no way I can kick it away. But I must move in with research, with people who know, who can help me to do things differently in the meantime. Yeah? Thank you.
Thank you. May I please ask that you keep your comments very brief, because we need to move on to the next session.
Will be the last one.
Shirami Shirinda is my name. This conference was very good for us here, but it's few of us. So my thinking is that taking it forward, we need to go back to the communities we represent to get people understand the way we have done here. For instance, a definition of a community. We can even get more ways of how to define communities if we are with the people, workshopping them, learning from them. Thanks.
Thank you very much.
Thank you for that. I'm seeing on the chat box, Richard Odende says, while organizing against the Bantustan mentality and protection against the state, it is important to think about the kind of state formation that we continue to embrace. And with that recap and a few comments that have been made in the different sessions, I'd like us to move on to the next session, which is the fourth plenary. And so without wasting any further time, can we please move on to that?
Thank you, Dr. Skosana, for that powerful recap, and for thank you, Dr. Skosana, for that powerful recap and precise recap, and for also allowing for other voices. Welcome everyone to the fourth plenary and the first plenary of our last day of the land conference. I'm Johan Lorenzen, and I'll be chairing this important session on concretizing land tenure security. Before I introduce the presenters, some brief housekeeping. Online participants, please keep on mute and keep your cameras off. And also, if you're online, there won't be any live questions. Only live questions come from the venues. So if online attendees have a question, post it in the chat box or at me on Twitter. After every presentation, we're going to pause for 5 minutes to give time for interpretation. And for those of us online, we won't hear those interpretations, so you can take that as a 5-minute tea break. Yeah, so just going into this session, over the past 2 days, as Dr. Skosana has summarized, community representatives, activists, academics, and lawyers have really illustrated the devastation of ongoing land tenure insecurity for rural citizens. And while mobilizing and litigating is mitigating some of this devastation, the conference has also really highlighted the very real limits on relying on lawyers in the face of state and company aggression. This was not meant to be. The Constitution guarantees tenure security, and Parliament was meant to give effect to this guarantee. Our first panelist, Zinande Boy, will present on Parliament's dismal and ongoing failure to give effect to this right. And she'll also highlight some of the lived realities of this failure for communities. We're lucky to have Zinande, an academic and a lawyer, to present on this topic. Zinande received her law degree from the University of Cape Town and then clerked for Deputy Chief Justice Dikgang Moseneke. Zinande then worked as a researcher for the Social Justice Coalition before heading to the United States to obtain a master's in international legal studies from Georgetown University. From Georgetown, Zinande moved on to be a Crowley Fellow at the Fordham University's Leitner Center for International Law and Justice. And it was during this fellowship, Zinande led a team conducting vital research on governance and land rights in South African communities. And I'll never forget receiving Zinande's write-up on her thinking on Indigenous governance and land law, being thrilled on how well it tied together so many issues that I see daily facing communities that are our clients. Zinande then came home, where she headed up the land team of the Land Accountability Research Center at UCT at LARC. And at LARC, Zinande's research and writing deepened our collective thinking around land tenure security, while she also did some remarkable lawyering. I'll never forget the late nights working on the Maledu amicus application, as well as fending off an urgent application brought by Tendele Mine in Somkele. Last year, we unfortunately for us, but fortunately for Zinande and the world, she was appointed as Executive Director at Fordham University's Center on Race, Law and Justice. And while of course she has a range of responsibilities at Fordham to highlight and support social justice causes in the United States and around the world, we are blessed that Zinande has kept up her hard work making sense of South Africa's challenges around Indigenous law and land tenure security. So with that said, Zinande, over to you. You have 15 minutes and 15 minutes only.
Hi, thanks, Johan, for that great introduction. I'm trying to figure out how to share the presentation.
Zinande, open up your presentation on your desktop or laptop.
It's open.
Then minimize it, don't close it.
Okay.
On your Zoom platform, there will be a screen share button that's green. Click on that.
Yes.
If you have sound in your presentation, on your left-hand side, right to the bottom, says sound audio, you tick that box. Otherwise, you just double-click on your presentation that's highlighted in that box.
Okay, is that working? It doesn't seem
we're not seeing it yet.
It's okay. It's really a summary of what's already written in my notes. So I'll just go ahead. Thank you very much.
All right.
Let me just then close this. Sorry, everyone. All right. Hi, everyone. So I'll try my best to do this without the PowerPoint presentation. I hope you're all doing well. I want to start off by briefly setting out the main point I'm trying to make with this presentation today. Since 2017, with the release of the Communal Land Tenure Bill, we have been waiting for a long-promised law that will deal with the many challenges faced by people and communities entitled to protection of their insecure tenure rights as required by Section 25(6) of the Constitution. However, unfortunately, previous, current, and future laws and policies that the state has either adopted or is proposing, including the Communal Land Tenure Bill, create legislative frameworks that fail to take into account the fact that as a result of either the lack of comprehensive frameworks that actually give effect to Section 25(6) and 25(9) of the Constitution, or the lack of political will or competence to implement laws that do exist that attempt to provide even some protection to these rights, for example, the Interim Protection of Informal Land Rights Act, or the operation of valid laws such as the Mineral and Petroleum Resources Development Act or the Upgrading of Land Tenure Rights Act. Communities across the country in the former homelands have been and continue to be dispossessed of their land and resources in violation of Section 25(6) of the Constitution, or they face imminent and present threats of dispossession that will likely result in them losing their land. by not even engaging with this undeniable and continuing reality. These proposed laws, as a result, do not provide people who have lost their land and resources any recourse or remedy for the unlawful dispossession of their land. What is particularly worrying and dangerous is that it does not even seem that this is on the radar of lawmakers or officials. There is an assumption that once a version of the Communal Land Tenure Bill is adopted, then the state will largely have completely complied with its obligations in terms of Section 25(9). Whatever the version of the Communal Land Tenure Bill does get adopted, the current and previous versions show that it will unlikely deal with the situation I've set out. And there seems to be no apparent discourse to at least consider adopting a law aimed solely at undoing the injustices of dispossession that have continued well into our democracy. For example, when civil society and affected communities made submissions to the Portfolio Committee about the impact of the operation of certain provisions of ULTRA, what those provisions of ULTRA have had on communities during the public hearing process where ULTRA was being amended, the legal opinion that followed from parliamentary officials gave the instruction to simply not deal with the offending provisions of ULTRA because the matter would be dealt with in the impending Communal Land Tenure Bill, and in the interim, communities and people would be protected by PLRA, and the committee was instructed to just move forward with the amendment without dealing with any of the substantive issues that were raised by communities. I'll give you a bit of a spoiler alert. People and communities are not protected by PLRA because state officials, companies, and private individuals act as though a PLRA does not exist. And laws that operate in violation of a PLRA are implemented as if it does not exist. No policy or draft law, or even CLaRA that was previously declared unconstitutional, dealt with this reality and provided communities with recourse and remedies in contexts when they've already lost their land. The state continues to legislate for the regulation and protection of tenure for communities and individuals in a superficial and piecemeal approach that ultimately either fails to address the underlying threats that these rights against these rights, which are deeply rooted in the continued impact of colonial and apartheid treatments of these rights. They also failed to address the failures and the chaos that continued in a democratic South Africa, and instead pass laws that reproduce and entrench what makes communities and individuals vulnerable to dispossession of their rights by them not being properly recognized or protected. Legislating in this way treats people that have had their land and resources taken away from them in violation of Section 25(6) as if they never had any valid rights that were unlawfully taken away in the first place. The only people being given any sort of recognition or protection by this proposed legislative framework are communities and individuals who, against all odds, were able to keep hold of their land and resources until a law was passed 28 years too late, and that's on the assumption that we even get this law this year. So I'm going to focus on how the Communal Land Tenure Bill or state proposed laws fail to recognize the reality of continued dispossession and thus fails to provide any remedies for individuals and communities. I'm going to focus on the operation of ULTRA in the context of the experiences of the Kwatinabakubo community in KZN. But communities dispossessed by the lack of implementation of the PLRA or the unlawful implementation of the MPRDA would be in a similar circumstance. ULTRA was adopted in the dying days of apartheid. It was a pre-constitutional attempt to reform the land tenure framework in which Black people were limited by the operation of the laws, policies, and practices of colonial and apartheid regimes. ULTRA is a sweeping law that has way too many issues to get into today, but very simply, it took the rights framework of permits, of PTOs, of quitwins, leases, and other occupation rights that were created and controlled in rural communities and urban townships by the state and granted to Black people, and converted them into title deeds through different procedures. It's a very simple explanation of ULTRA, so please forgive that. ULTRA still refers to traditional communities and as tribes in the text of it. So I'll be using the term tribe for the rest of the presentation when referring to the language that still remains in the Act. The majority of the provisions of ULTRA deal with individual occupation rights granted to Black people by the state. However, one of the stated objectives of ULTRA is to provide for the transfer of tribal land in full ownership to tribes. To that end, under the miscellaneous chapter in the Act, sections 19 and 20 deal with the transfer of land to tribes. Section 19 provides that a tribe can obtain ownership of land and can dispose of that land subject to limitations provided for in subsection 2. Subsection 2 provides that a tribe cannot dispossess of its land to a person that is not a member of that tribe for a period of 10 years from the date that the Act came into operation. During that period, the tribe can only do so on the authority of consent granted by a court. To grant this consent, a court must be satisfied that the dispossession is authorized by a tribal resolution, the proposed disposal is not in conflict with the interests of the members of that tribe, and alternative land is available, and the people who live on that land have waived their occupation rights to that land. This requirement of court oversight in cases where tribal land was being disposed, expired in 2001. After that, there is no such requirement that exists. And since there is no requirement to inquire about the impact that any disposal of tribal land will have on the members of that community, or the rights, or what rights are implicated by that disposal, or whether any laws that are relevant are actually complied with. For example, in each of these contexts, does the PILRA apply? And if it does apply, has it been complied with? None of those inquiries are required by ULTRA at this moment if a tribe or a traditional community, as we refer to them now, wants to dispose of land that's been transferred in terms of it. And then the question then becomes, how have these provisions operated in practice, and what has been the impact of their operation on individuals and communities that these provisions have been applied to? To illustrate how these provisions have operated, I will be referring to certain aspects of the experience of the KwaDinabakabo community in the KwaZulu-Natal. In 1983, the KZN government began negotiations for the construction of the Inanda Dam. This would result in the displacement of a number of traditional communities, including a portion of the Ngolosi tribe. It was agreed that the South African government would provide compensation, and any compensatory land would be vested in the South African Development Trust. Land was identified from the Ngolosi tribe, in which a portion of that land was primarily agricultural land, and a portion of the land was earmarked for urban development and was eventually developed into a township for the displaced members of the community. My focus will only be on the agricultural portion of the identified land for the community. With the dying days of apartheid, the land could no longer be transferred to the South African Development Trust. Instead, in April of 1994, the agricultural land was transferred in the name of the Ngolosi tribe to be vested in their chief. That transfer took place in terms of Section 20 of ULTRA. Since that transfer, unbeknownst to the displaced members of the community, portions of this land have been sold by the traditional authority under a power of attorney granted to chiefs to 17 individuals. Two larger remaining portions, one of those remaining portions was sold to a eThekwini municipality in 2010. The transfer deed reflects a huge amount was purportedly paid for this land. This is ostensibly to defray costs of rates and taxes, but it's not very clear exactly what happened there. In 2016, another larger portion of land was donated to a development company, and it appears that the chief is the director of that company. As I mentioned above, because of when these transactions took place, where these sales took place, and when these transfers took place, there was no requirement of judicial oversight. Even though that particular remedy is not always perfect and is not always appropriate, there was absolutely no engagement with the impact of any of the transfers would have on the impacted community. When members of the community wanted to make use of the agricultural land, they discovered the sale and transfer of their land. They tried to find out how this had happened without their knowledge or consent, but have been sent from pillar to post trying to get answers and raising concerns of corruption. They have not been able to get any clarity about the details of how and why these transfers occurred, or have not had any resolution in that regard. In trying to get some sort of remedy, they have engaged with multiple institutions, including the Public Protector, COCTA, and the Department of Rural Development in KwaZulu-Natal. During one of those dispute resolution processes, both COCTA and Rural Development were required to participate, and each had to provide reports. In any of those engagements, there's been no, the ruled that neither of these departments have actually engaged in what it means for this land to have been transferred and can provide no answers as to how it happened without the knowledge and consent of those directly affected community members. Now, with that sort of context in mind, and then we look at the current version of the Communal Land Tenure Bill. The Communal Land Tenure Bill, if it would be adopted in its current form, would repeal sections 19 and 20 of ULTRA. These are the sections that allowed this transfer of land. However, nothing in the Communal Tenure Bill will provide any remedy or recourse to communities in situations similar to that of Dinabaku. It is not clear how many transfers of community land have happened in terms of these provision of ULTRA and what the status of this land currently is. And I'm only just talking about ULTRA. Communities dispossessed by the unlawful operation and implementation of the MPRDA in violation of the PILRA are still in a similar context. The Maledu judgment is a good start, but it provides no real remedy for many communities that have already been dispossessed of their land. Communities that have been dispossessed of their land as a result of the improper or lack of implementation of a PILRA are also in a very similar situation. The Baleni judgment in relation to the Kolobeni community is also a really great judgment, but again, no real remedies are created for communities that have already been dispossessed of their land as a result of lack of government action and as a result of lack of implementation of existing legislation. So when you attempt to legislate with no real regard to the reality of the context that exists, only means that many of the communities and individuals who continue to bear the brunt of South Africa's legacy of injustice and dispossession continue to remain on their own. Thank you.
Thank you so much, Zenande. That was fantastic. Where just for those who missed it and who are online, we now take a 5-minute pause to allow for translation in the physical venues, and then we will have Professor Ben Cousins up next. I'll do an introduction for him and then hand over.
Thank you very much. Zenanda Boy, once a student from UCT, and now actually based in Forthcoming University, ulikile go susubanya matata a kere uwa ka masuba a leng teng mo molaong wa mafatshe a tshwereng ke rona ba tswang ko di-community. So sa se tlhalositseng o ile gore go na le melao e le gore e bile ya seke ya diragatswa go tswa ko kwalowe. O ile ka section 25 ya molaotheo a bua ka appeal re bua ka yona, a bua ka MPRDA, a ba tlhalosa batho ntse ba tswelela pele ntse ba tsena mafatshe a bona, which is actually in violation ya section 25 ya molaotheo wa rona wa South Africa. So tsweletse pele gape a bua gore ba dira melao e ga mmogo le badiri ga ba tseitsia ga ba dira melao e ya bona ditletlebo tse batho ba di buang mo dikgotlakgoteng ga go dirisiwa melaotheo e diriwa ga ba tseitsia ditletlebo tsa batho, mme ebile o tlhalosa gore molao wa ipira o le gore o sireletsa batho le go nagang ko o tsewa tsia ga ba tsaya ditshwetso ba tlola molao wa ipira o. Mme o buile gore ditshwanelo tsa batho di ntse di gatakwa go simolola kwa lowe ka colonialism ga mmogo le apartheid le ka di-TB state tsa kry-a di Transkei Venda Botatswana yalo le yalo bagaetso le bolo ba kgomo. Mme o tsweletse pele gore yona puso ya rona e ntse e tsweletse pele ka yona melao ya kgatelelo ya colonialism le apartheid go gatelela ditshwanelo tsa batho. Mme o tlhalositse gape go ka section 19 le ka section 20 e le gore e lebeletse gore mafatshe a batho ba ba tswang ko segosing ke yona mafatshe a le gore a fiwa borra dikgwebo gore ba dire dikgwebo mafatsheng a bona. Mme o tlhalositse gore ka 1983 gape go ne go na le dipuisano mabapi le go aga dikgwebo mo mafatsheng a batho, mme ebile go letse batho ba tshwanetse ba fiwe ditebogo ka lefatshe la bona because of ba bile ba tlhokafatse la bona ka ntlha gore go ne go lebetse gore go agiwe dikgwebo yalo le yalo. Mme a tlhalotsa gape gore ka 1994 ko KwaZulu-Natal go ne go tsweletse pele ka go tsela batho lefatshe ebile ko bofelong go na le kampane e nngwe e tsetseng batho lefatshe e le gore kgosi mo teng foo e ne le directora ka mogare ga kampane eo ke mathata a leng teng gore magausa a rona ke right le bonyala la piane ke mathata a leng teng ke motshwareli wa kgosi ka fa ebile ka fana o na le di-company tse fetang 50 ke di-directora mo gotlhe mo se kgone ba ikgotlaganya le ba puso ba rata batho ba ntseng bjalo ka gore ba ja mmogo akere ba gaetso ga ba phufura ka fa le bona ka fa ba phufura ke mathata a e leng teng mme ko bofelong ga gona mo go beiwang teng gope morafe mo teng lona morafe le wetse ko thoko ga bana sepe le lona a kry so ke mathata a leng teng ba lebeletse matshofu bagosa ga mmogo le borra dipolotiki mme ba lebala morafe mme ko bofelong ga morafe o simolola o una ka lefatshe leo a kry bona ga ba ba tseitsia ke a leboga ba gaetso.
All right, we are back with Professor Ben Cousins, and I'll do a very brief introduction because this is a man who really needs no introduction, given his extensive research and writing as the founder in 1995 of our co-host UWC's Institute for Poverty, Land and Agrarian Studies. Ben completed his doctorate at the University of Zimbabwe, where he did research on communal grazing, livestock, and production, building on the work that he had done while in exile. He served as GLAS's director for 14 years while doing extensive research and writing, which he continues to do. He was a DSD NRF research chair in poverty, land, and agrarian studies from 2010 to 2019. I'll maybe just mention an anecdote. Zenande spoke about the importance of the interim protection of the Informal Land Rights Act in shielding rural citizens. And giving effect to Pilra's promise is probably the biggest part of my legal practice. I first encountered a Pilra in law school in a class called African Customary Law, where we were assigned Professor Cousins' writing. Professor Cousins' powerful and clear writing on the nested nature of Indigenous land tenure was a central part in my journey of making sense of a Pilra as meaning something more than simply a majority vote, as it's so often interpreted, but as rather a shield of protecting existing, robust and rich Indigenous land rights. It transformed my thinking. And so Professor Cousins will pair very nicely, I think, with Zenande's presentation on our gaps and failures as he presents on strategies for achieving land tenure from below. And Ben, maybe just before you go, I'll just note some of the comments we've already had, as you might want to engage with them. Obey Mabena said, amongst the myriad of tools and the vast arsenal of tools used by corrupt government officials frustrating struggles of land-deprived communities, is that of using unscrupulous members of the community and traditional leaders to sow disunity amongst communities that are fighting for land reform. And Tinyiko Mbense said, it's all by design. I recall when they tried to build our own park in our neighborhood, we told the land belongs to ESCOM. Douglas Kivoy says, African governments currently busy leasing out community lands to foreign multinational companies. Communities that resist are met with brutal response from security forces. So with that, over to you, Ben. Thank you. You have 15 minutes.
Thank you very much, Johan. Thanks to everyone. I've enjoyed the conference so far very much, but I must also confess to a slight sense of disappointment in that I don't think any speaker so far sufficiently acknowledged the depth of the crisis that we're in. A crisis not only of state capture and state dysfunction, but also the wider social and economic and governance crisis facing our society. And we are not the same country that we were 4 years ago. And I don't think we're taking sufficient account of the limitations on our past strategies and the need to come up with new strategies. That is the main thrust of my presentation today. I'll go quite quickly through a number of slides. So my presentation is entitled Tenure Reform from Below in an Era of State Dysfunction. And here is my key argument. My argument is that the key focus of civil society to date has been tenure reform laws and policies at the national level, but elite capture and state dysfunction mean that at the moment, positive gains are unlikely in respect of either law or policy or implementation. Rather, I think, civil society should refocus its efforts on local struggles through democratic politics and a number of solidarity alliances. In other words, a rethink is necessary. So instead of the arrows all going up to laws and policy, I think they need to come down to building a social movement. This is my outline. I firstly ask the question, are what I call social tenures subject to social change? Yes, they are. And I want to show how things have shifted over the last 10 to 15 years or so without changing the basic characteristics of land tenure systems in which people have rights as members of groups. Secondly, I want to consider this question of prospects for tenure reform in a period of state dysfunction. Have another look at the question of political embeddedness, which is one of my part of my model of how land tenure systems work in Africa. Look at some lessons from recent experience, and then take up the question, how can we build a social movement to push tenure reform from below? So this is my diagram, which I developed about 17 years ago and wrote an article about it, which Johan referred to, in which I talk about socially and politically embedded land tenure systems. Social relations are central in these. Social, political, and resource boundaries are flexible and negotiated, and these systems are politically embedded. Power relations and processes are central. This means that authority and power are dynamic and variable. The balance of power between different levels of authority and between rights holders and authority shifts over time. And I should add to that the balance of power between different rights holders themselves in the community shifts over time. So this was my model. And when I was first asked to write this paper, I was asked to review the evidence. Has it shifted over time? Is it any different to how it was when I first began to work on this? So I've reviewed a lot of papers. I've read about 30 to 35 papers, and I have concluded that a great deal is changing. Social tenures are subject to social change. There are some positive changes. Actually, rural social tenures are not found only in rural areas. They're increasingly found in urban and informal contexts. They remain socially embedded and socially homogeneous, but increasingly now people come from different backgrounds and have different languages and are heterogeneous in a variety of ways. The question of allocation to legitimate rights holders remains a powerful feature of these systems, but is increasingly a question of now allocating land to those who need it, not only those who were born or who have ancestors in a community, particularly, of course, in urban, peri-urban, and informal settlements. And traditional authorities are not the only ones allocating land. We have committees, we have CPAs, we have SENCO, and so on. But there are also some negative changes. Some rural settlements are now densely settled. They have urban characteristics. I'm thinking of large areas outside, for example, Polokwane or in Bushbuck Ridge, which really look quite urban. They're densely settled, and in many cases, they're dormitories for urban workers and for those receiving grants. Of course, they still live under chiefs, under traditional authorities. And increasingly in these kinds of areas, civil servants are using their housing allowances to build houses for themselves, sometimes to rent out. Often they're not paying for services, or they're not paying any rate, so it suits them. And often they're investing in cattle herds. So mansions are going up in so-called rural areas. This is a very different situation to the one that we think about when we imagine a rural community. There's often not enough land for cultivation, and chiefs and sometimes committees charge fees or take bribes for people to give plots to people to build on. So social change can be both positive. I think what we've demonstrated here is the flexibility and adaptability of customary systems. They adapt to change in society, but they can also have negative kinds of changes as well. It's not a simple thing. And just as living law implies that law changes and adapts over time. I think the same applies to customary law. One of its key characteristics is its nature. It's built on process and it's built on social change. It is adaptable and flexible. This is one of its inherent strengths. And of course, this is how common law changes over time as well, as Sindiso pointed out on day one. And the Bayer judgment of 2005 tries to capture this by talking about living customary law, acknowledging that the rules are adapted to fit in with changed circumstances. But the question arises, whose interests are served by changes in living customary law? What I would argue that this is partly a matter of local politics. In other words, we have to see law, all law, not only customary law, but all law as politics by other means. So, coming to my key question, what are the prospects for tenure reform when the state is incaptured or incapable? And as I indicated earlier, we live in a time of severe crisis, severe economic, social, political, governance crises. Is it appropriate to carry on our struggles as we have in the past? So I would argue that it's clear from everything that everyone at this conference has said so far, that the policy stances of the ruling party and the state are strongly pro-chief in rural areas and strongly pro-titling in urban areas. So we've got that major obstacle. What are we going to do about it? Is it possible to change that? So let's look at some of the negative aspects of our strategies to date. Yes, we have won some successes. Yes, we have had some legislation struck down, and we've had other legislation altered. Has policy really shifted? Has that policy, as the stance of the state shifted? Is there any kind of implementation of a progressive policy likely to happen? Well, contesting policy or the constitutionality of legislation is, of course, long-winded and costly. And it ties up lawyers, researchers, and activists, sometimes for years. Success is never guaranteed, as we've seen with the TKLA. And meanwhile, on the ground, as we've heard in the conference, ordinary people remain vulnerable to corrupt chiefs, mining companies, other business people, while this litigation and policy advocacy proceeds often quite slowly. So I would argue that we actually have to rethink what we're on about here. We have to adopt a different mindset, and I'm going to try and spell out what I think it should be. Let me return to the question of political embeddedness, i.e. the idea that authority and power relations are dynamic and variable. I want to quote from Celestine Nyamo-Musembe's work. The further removed the formal law and policy is from nuanced practice at the local level, the less relevance and legitimacy it will have in people's lives. People are politicized because they know that the formal law and policy is not relevant and legitimate in their local context. And the community members and the activists who are here can bear testimony to that. To quote Aninka Claessens, the living law approach includes the multiple actors who are engaged in confronting, negotiating, and changing property relations and power in day-to-day struggles. So my argument is this: should, as civil society, not focus its efforts on helping people to win these day-to-day struggles? Should we not shift attention away from national policy, legal frameworks, down to people on the ground, where they are attempting to engage in those day-to-day struggles and help them to win those struggles? I would argue that land struggles do not occur in isolation from struggles in other areas in society within the wider political economy. This was true in the period of apartheid. If we think about the Ponderland Revolt, the challenges by radical youth to corrupt traditional leaders in the 1980s, they were part of a wider set of struggles. And I think it's equally true now. And so I think we have to relocate tenure reform and our efforts to protect people's rights in another kind of wider political context, a post-apartheid democratic project, which is now under threat. And if we are going to recover it, we're going to have to go back to the trenches of struggle. So where do these struggles break out? They break out in relation to a huge number of disputes, many of which we've heard about in the conference today. Who is entitled to be allocated land? Who owns land? How is land allocated? Is the payment of a fee necessary? Who decides whether or not to grant land to an investor or a developer? Who benefits from such development? Should people be compensated when their land is used for development? What roles do headmen and chiefs play, and so on? Who owns land transferred through land reform? All of these are not only disputes, but they are sites of struggle. Are there lessons we can learn from struggles in the past? Well, my attempt in the paper is to draw lessons from 3 struggles. I mentioned only one here, the case of Motwaneng in Ragwadi, which Anenka wrote about in both 2001 and 2008 in our book, Land, Power and Custom. And there are many lessons you can draw from this extraordinary tale. We don't have time now to go into detail, but basically, this particular community had a history of independent land rights, were placed under a powerful Khosi, Chief Matlala, who was previously a minister in the Lebowa government. Matlala took transfers to the tribe in early 1994, just before the democratic elections, but this is now inaccurately perceived to give title to the Khosi. It's not actually the case. But he allocates lands to outsiders. And if people march against him, as did the Motwaneng people, saying, please, Khosi, we actually own this land, please acknowledge our rights to it, they are met with repression. They were forced to stand in the sun for an entire day, not being allowed to go and relieve themselves, and subsequently they were abused and they had to retreat. The problem here was that they fought that battle on their own. They were isolated from others. There was no solidarity possible from people fighting similar struggles. Hopefully, with a movement, a social movement, today we can overcome that isolation. So there are important lessons to learn from such cases. History counts. There are very complex local histories, which Anenka's analysis lays out. And this is true for every local situation. It is always unique. It is always complicated. And local struggles are rooted in that complexity, rooted in those circumstances. So one size does not fit all in terms of our strategies to try and succeed. People, I think another important lesson, people do not see any contradiction between custom and democracy, between rights and culture. In both systems, in fact, there's an emphasis on local decision-making, participation in debates, seeking agreement, and requirements for accountability. And of course, accountability to the people, which is a key value in both systems, is a threat to powerful autocratic elites and their partners in crime, like mining and other companies. But actually, the power of those elites can be countered by successfully asserting the power of community members. But to do so, we have to overcome the relative isolation of local struggles. Support from wider alliances is often needed to succeed. And of course, there are also examples of some successes. For example, the Amadiba Crisis Committee in respect of mining in Kolobeni, which we heard powerfully about just yesterday. Some communities exert their power to disrupt or prevent elite projects from taking place. Most rural communities do not exert much structural power, but when they are disrupting projects of the elite, they do in fact also exert structural power. So my key questions: can a democratic politics be combined with one focused on rights derived from custom? I think they can. What laws provide protection of land rights and guarantee the right to engaging in political activity? We actually have made huge advances since the advent of democracy in South Africa. Our constitution is vitally important. And we've won some struggles with respect to land rights as well. It's important to build on the political space and the protections that they provide to further the struggle in the current circumstances. Some legal judgments and precedents can be brought to bear. And I think we need to ask another question. Are we talking only defensively, or can our struggles also in some way be transformative? Can they have a wider ambition? Can they seek to engage in a struggle to transform society more generally, which is so urgently needed as we slide backwards to the rule of gangsters? Must struggles be focused only on land rights, or can they be combined with other issues like access to water or land for farming projects. I would argue that it's important to recognize that they often are connected to a range of other issues. So we should not focus only on the land aspect. We should focus on those connections as well. A big question is, what forms of organization are most effective at the local level? There are a variety that people use for foundations, associations, development forums, and so on. And a key question, how can solidarity alliances be forged across different communities? The Alliance for Rural Democracy is a model here. Either the ARD or other formations, I think, have tremendous potential to grow, to have much larger membership, given the crisis in our society. And a key question always is, how do we keep honest leaders both honest and accountable? Here are the important lessons from the trade union movement, where I think we all seen how things can go so badly wrong. In local struggles, some difficulties must be confronted. Local and
Ben, you're over your time, so if you can bring it to a close.
Very soon. Local and external elites have powerful allies in government, and even non-elites, ordinary people, ourselves, can be divided by class, gender, and other interests, and the notion of community can mask these divides. Isolation undermines morale. There are actually relatively few lawyers with relevant expertise available, and most lawyers charge fees. I know our LRC, SPUA do not, but others do. Retaliation and repression is often the cost of struggles, and you need a lot of courage. There can be terrible consequences if things go wrong. So my main proposal is that we should focus mainly on, we should not have to choose between law and policy and local struggles. In fact, even if we give more emphasis to local struggles, we need to maintain an emphasis on law and policy and use them where possible to help people win the local struggles. So it's both, it's and it's not in one at the expense of the other, even though I think the emphasis now should be building from below. I would suggest that we need to build a broad social movement with maybe more than 100,000 members. We need to build solidarity alliances laterally, so activists in different locations can support one another, as well as alliances vertically between activists, lawyers, and researchers. We need to focus more on land for what, not only land in itself, and we need to build links with progressive movements and initiatives focused on issues other than land, like jobs, grants, agriculture, and so on. So it's a dual focus. It's dual and complementary. There are massive obstacles to building this today, which I don't have time to elaborate, but I do have some practical suggestions for both lawyers and researchers about establishing networks, about starting projects, about creating a pro bono network and asking law firms to sign up for this network, and so on. So I think there are a whole range of things we can practically do. And to finish up, I just want to say that in building a movement for tenure reform from below, connecting up to the wider struggle to bring South Africa back on track with the democratic project, I think we can combine custom and democracy. And to quote Mahmoud Mamdani, a democratic appreciation of the customary must reject embracing modernism or traditionalism. It needs to disentangle authoritarian from emancipatory possibilities. And finally, to say, the title of plenary 3 yesterday, self-emancipation from below, to me captures the urgent need of the moment. And I hope we can have more discussion of this. Thank you.
Thank you so much, Ben. We are now going to take 5 minutes for interpretation in the venues. Professor Hall has had a great suggestion, I think, of using this 5 minutes for those of us who are online to have discussion and engagement. So I did ask if anyone wanted to specifically speak on the online session, but I didn't. I've seen lots of great comments, but maybe if people can, if there's anyone who wants to, particularly anxious to speak speak up, feel free to raise your hand. But in the meantime, I think I'll just highlight some of these excellent comments. Yeah, Vishwas.
Thank you to the panelists. This is great so far. Just to kind of pick up on what Ben was raising, the provocation and the challenge to us, I think he's really on the mark in terms of provoking us to think about a new paradigm of power. But it's not a new paradigm per se. And I think there's a whole litany of historical examples that we can draw from to rethink a new politics of power from below. The labor movement has given us some examples, and he's alluded to that. There have been other kinds of social movements around water, etc. And I really think that this new paradigm of power has to recognize the challenges of the climate crisis and the just transition. I think this is the key frontier for most of our struggles. And I really think that the notion of democratic systemic reforms is something we need to think about. You can have weak reforms, you can have strong reforms, and you can have transformative reforms. But crucial here is building structural, systemic, moved, symbolic, and even direct forms of power. I just want to leave that there in the conversation. Maybe Ben has other thoughts and the panel. Thanks.
Thanks, Vishwas. Don't see any other hands. So let me just look at some of these comments. Andries du Toit said what Ben is saying about the dynamics of land struggles in local settings is not only true in rural areas. Similar conflicts around occupation, eviction, the right to remain on land occur in urban areas. Is there space for alliances around land struggles across the rural-urban divide? Tana Mahoka agrees with Andries about the urban land struggle and linking it to wider alliances. Rudy says Ben is summing up so many relevant issues. Great. Andries, again, a further fascinating implication of Ben's argument is that land struggles cannot be seen in isolation from a broader struggle for democracy, to fight for South Africa as a land belonging to all who live in it, against the power of corrupt officials and the gangsters. There's space to link land struggles more explicitly to the struggle for renewed struggle for the SA democratic project. Itumeleng says, to respond to Prof. du Toit, would the trigger not be the material conditions of people in both rural and urban areas that would ultimately determine the extent to which they become conscious about these things and then realize, as Prof. Cousins said, that the post-apartheid project is under threat? It can only be recovered by a back to the trenches approach. If the organizers can maybe give, it looks like the translation, Reverend Mabusa is still going there in Durban. So Ben, if you want to take 60 seconds.
I just want to respond to what Vish said. I think the ecological crisis is not something happening somewhere else. And it's not going to happen in the future. It's happening right now. And it's one of the reasons why there's a crisis of livelihoods, a crisis of cost of living, as they put it. It's because, in part, of the climate crisis. Of course, it's the failure of neoliberal capitalism as well, which is, of course, one of the prime reasons for the climate crisis. These things are not outside our lives. They're partly why you don't have a job, you don't have income, you're struggling to survive. It's why elites are trying to get hold of your land. They're trying to recover their profits in a situation of crisis. I think embracing the climate crisis means taking livelihoods, and in our case, land-based livelihoods, much more seriously. And I really think this division between land rights on the one hand and how people make a living for themselves on the other has to be overcome. And I know that in real life, in people's own lives, those connections are there. They are made. But I think as analysts, as researchers, as lawyers, we don't make those connections. And I think we are partly at fault for not providing adequate intellectual leadership to these struggles.
Thank you, Ben. Looks like we're still going with okay, we are now being asked to mute online. disrupting the responses from translation. But thank you for that stimulating
Communal
engagement.
Property Association le tše dingwe and the rural area tše dingwe di šetše di tletše ka batho mo leng gore tše dingwe ebile šetše di tšea sebopego sa metsesetoropong and go ira gore re fetša re sena le babu mo leng gore o ka lemuwa gona and ba bangwe ba dikomiti le magoši ge ba efa batho ditsha ba tšhatša ditšhelete tše leng gore ke tša godimo ba bangwe ba kgone go fitlhelela mo leng gore ge re lebeletše tshepedišo ya ditaba ka molao wa rena wa setšo re swanetse go lebelela gore go be le go akaretša democracy ka mogare ga yona ka gore ge re ka lebelela go šomiša dilo ka tsela ya molao fela wa setšo o ra gore re sa boela morago mo leng gore ye nngwe ya dilo tše a di lebeletšeng gore re ka ithuta go dikgwabo ka seboka tša ditlhopha tše dingwe tše e leng gore di bile gona mo Afrika Borwa o bontšhitše ka case study ya ko Motwaneng a Rakgwadi gore history kerare tseba tša kgale ya gona e bontšhitše gore batho ba ipile le ditokelo tša naga tša o ikema and go ile go ba le council tša ditšhaba tše e leng gore di bontšhile di na le maatla and di be di kgona le go tlhotlha bogoši and ebile ne ba sa tšhabe le go bolela ka phatlalatšo gore ga ba kwane le ntho e itšeng and o khumana go na le mantona a mangwe a e leng gore a tloga a e ba ka godimo le ka go tsebega go ba le go ba le tshego go feta bogošing and then ge re lebeletše re ya pele le rona ka ithuta go tšwa go history ya rena go ira gore bjale ka Afrika Borwa re swantse gore re ithute go tšwa go batho ba kgale goba ka mogolo di dira ka gona ka gore batho ne ba sa lebelele taba e tee fela ge e le gore go na le batho ba ko Pondoland ge ba dira struggle sa bona ne ba se tlhakantšitše be le taba tša mešomo e ba taba tša bodudi e ba le taba tša kgatelelo tša apartheid le ntho engwe le nngwe le rena gane bjale tlhotlho e kgolo ke gore na ge re lebeletse merero ya mabu re ka tsentšha eng ka gare ntho e tlo kgona go tia gore di-struggle tša rena mo fase di tlhakane and re tlo kgona go dira kgwerano e se ka ba gore ge e le gore ke batho ba mmamotitane ba e leng gore ba lwela taba ya naga ke ba mmamotitane ke taba ya bona ba itse rena ga re itsene re tlo kgona gore ditšhaba tša kgausu le tša kgole di die kgwabo ka seboka di tshegana le bao go tseba gore struggle sa bona ke sa rena re se ke ra šoma re le o mongwe a le kua re le badula thoko a re se ka ra dia modula thoko e poloke rata a re šome mmogo ke mo leng gore re tlo kgona go huetša seemo sa ditaba mo re beng gona mo leng gore ge re ka lebelela taba ya mmereko wa peakanyo leswa ya mabu kudu go dina semagae a e nyake re lebelela gomme taba ya tshepedišo ya dilo ya custom fela e nyaka re tlhakantšha custom le democracy mo leng gore e tlo kgona gore e re bontšhe gore re kgone go tlhotlha re tlhotlhe setšo sa kgale le go tlhotlha dilo tše diswa tše e leng gore di ka ba di tla le tšwelopele e tla ka gona and then ka mokgwa go ra gore re tlo ba re lebeletse rena context re phelang ka gare ga yona e nyaka re dia dilo ka tsela mang re se ka ra ba rigid ra sola ditonki ra lebelela felo go tee ke a leboga.
All right, we are back together, and our apologies from the online cohort to the physical venues. We got a little bit excited about these topics and couldn't help ourselves and kept going, but we'll manage that better on the next time. We won't have any more additional plenaries. So we've had excellent presentations from Zenande on this intense failures of Parliament, and Ben on strategies for bottom-up approaches, both to change policies, but also to make sure we're dealing with them as they are. And I think one of the reflections from the land conference is, from many of the presentations we had yesterday, is that we have so much to learn from comparative experience regionally, continentally, and internationally. And that's why I'm very excited to have Dimuna Piri joining us as a discussant for the final presentation. And Demuna holds a Bachelor of Laws degree and currently finishing her master's. She's a legal and land administration specialist at Land Equity International. She has progressive leadership experience at both local, regional, and international levels in Zambia, South Africa, and Australia. In her recent past work, she's worked on land-related projects on renewable energy in Bangladesh, infrastructure development in Nauru and Fiji, focusing on legal, social safeguards, and gender. She's proven experience in customary and statutory land tenure regimes, land governance and land administration, social and economic development, gender disputes resolution, legal and policy reform. She's a broad range of experience working with private sector and nonprofit organizations, as well as strategic partnerships with government. Demuna, over to you. You have 15 minutes.
Okay. All right. Thank you, Johan, for that introduction. And I'd just like to thank Zenande, and I'd like to thank Ben for their great presentations. I think they've done quite a very good job in trying to highlight a lot of, I think, issues that pertain to customary land rights, pertain to customary land tenure in itself. And with Zenande's presentation, she particularly referred, I think her approach was mainly looking at the rights-based approach, looking more on the legal perspective. And she highlighted quite a number of pieces of legislation that I think she brought out. Same with Ben. I think his approach was mainly using a social, political economy kind of analysis, even as he was talking about some of the key issues that pertain to customary land tenure. And moving forward in terms of application as well as to the Customary Land Tenure Bill. So Zenande analyzed and compared the Communal Land Rights Act, which has since been repealed, and also the Communal Land Tenure Bill, which is currently before Parliament, and the Interim Protection of Informal Land Rights Act. And she compared this as it relates to the communities. And she also brought out quite a few aspects from the legislations, meaning highlighting that legislation often significantly weakens the rights of individuals and communities. And she also talked about the fears of repeated failures in the protection of customary rights, and that communities' concerns are not considered in the process. And I think we see this as well highlighted from Ben, where he constantly refers to the social issues, and that the customary land tenure or customary land system is quite very dynamic. It's quite very diverse in its own way, and there's need to consider the social relationships that are prevalent there, the social identities as well, which are constantly multiple, and they definitely overlap. And he's been referring, even in his papers, to this nested or layered character, that there's need to ensure that all that aspect is constantly considered. He also brings out quite a lot of an angle of rights. You know, I derive primarily from accepted membership of a social unit. So again, linking it to Zenande's presentation, and he had discussion regarding the social unit perspective, and that individuals actually attain rights by being in that social unit. And we see that all that is not considered fully within the pieces of legislation. Hence, I think the disadvantages that they have caused even unto the community members. Zenande also pays particular attention to the fact that the states has also been obsessing concerning on the aspect of titling, and that the transferring of land rights sometimes from traditional leaders or to traditional leaders, or even just customary landholders, sometimes does not also, again, going to Ben's discussion, does not consider, you know, the actual cultural dynamic or the actual cultural customary land systems in that regard. Then similarly as well with institutions, they're not very considerate of this fact. Zenande mentioned that. And in one of Zenande's case studies, she shows us how application of laws can actually infringe and bypass the importance of traditional customs that require communities' consent. And she talked about the Upgrading of Land Tenure Rights Act, where I hope I pronounce it right, forgive me if I don't, Kwadina Bakuwa community had some issues, concerning their land, and traditional councils, or the traditional council, got to actually be able to make a decision on behalf of the community members. And I think this decision was not the right decision that was made. And I think, again, the piece of legislation failed the community members in the event, in the sense that it actually progressed a decision with the council, but that did not necessarily interpret that it was the decision that was made with the community. So there are those kinds of issues that I think are highlighted in both Zenande's and Ben's discussions. And coming to other examples, for instance, that I'll also give, is South Africa the only country that is going through all these challenges? Clearly, no. There's so many other countries that are specifically having challenges concerning customary land tenure, customary land rights. And I'll talk about Zambia. Similarly, quite a number of people in Zambia, communities that are on customary land tenure, have suffered dispossession as well. And this can be due to mining, this can be due to commercialization in terms of agriculture, and it can be due to other ventures that aim to progress economic development. And we see that there's so many of those issues. There is a customary land administration bill. It's been sitting since 2014. It has not been enacted into a piece of legislation, and it's because of the issues, I guess, the politics that arise when it comes to even enacting customary land tenure. And even just within Australia, there have been struggles as well concerning Indigenous people's land rights, and how they interface as well with the statutory system, as well as their recognition of those rights within the in the current setting. And quite a number of them have also faced quite a lot of dispossession. And recently there was a mining company that actually got to destroy a cultural heritage site. And they mentioned that they didn't know that that was a cultural heritage site. And the Indigenous people were actually very upset about it, because again, it reflects to the fact that there is no proper consultation or engagement with the local peoples that live in those communities to actually know what is it that they consider sacred, what is it that they consider not sacred. But again, when pieces of legislation have also failed customary land holders, because in terms of cultural heritage, you'll be told, map out or tell us where your cultural heritage site is. And we put that into a record. That is currently happening in Australia, where there is a database and you need to actually record that. But then with the Indigenous people, they're pushing back and saying, everywhere we go is sacred. It can be a river, it is a sacred, it can be a song line where elders usually used to travel in the past, and it's a path that used to lead them from one place to another. That is sacred. So how do you map up some of these things? It can be a tree, it can be a sacred place. And how do you put all that into a database? And I think those are the challenges that laws have actually, I think, failed to address. If you apply the law to customary law related issues, you find that those challenges come up. So what are some of the similarities within all these jurisdictions? South Africa, Zambia, as well as Australia. I won't talk about any other because I don't have much time. So all of them definitely have experienced colonization. And some of them, like the South African Constitution, as well as the Zambian Constitution, recognize customary land, that it exists. But the Australian Constitution doesn't. And the reason for this is that the Zambian and the South African constitutions were recently enacted in 1996, 1997. But with the Australian Constitution, it's still really outdated, and it still has racial discriminatory provisions, even with it, not just to the Aboriginal people, but to even others within Australia. And then there's also social and social and moral standards, which form part of customary law. You see that this is constantly consistent within all the 3 countries, and the application definitely of the westernized statutory interventions have definitely proved challenging for all jurisdictions in terms of customary land. And customary land dwellers in all the 3 countries also face land rights infringements and dispossessions, which are facilitated by economic development. And there's definitely limited effective engagement with customary landholders in economic development projects on customary land. And I think that's something that has been highlighted throughout the conference as well in South Africa, but it's happening in the other countries as well. Then the land rights protection and realization threats are definitely prevalent. And we see sometimes that even the statutory legislation itself can actually exacerbate some of these threats concerning protection. And I think, again, it comes back to the case that Zenande mentioned, a practical case where a community faced the challenge. And then again, there's lack of effective mechanisms for grievance claims. And even if these mechanisms have been put in place, there's been quite a lot of challenges for community members to actually either access or ensure that their grievances are properly addressed. And also there's definitely institutional failures. And Ben, I think, talked quite a lot about this and that we need to look forward. So what are some of the common mistakes I think that have also been made? We see
Sorry, Dimuna, I'm not sure if you're seeing your chats, but given the time, we've been asked if you can wrap up in the next 60 seconds if possible. Sorry, sorry about that.
I just have one last, a few last things to talk about. I'll be wrapping up just now. So some of the common mistakes that we see, definitely, it's interpretation of the dynamics of customary land tenure through statutory law. And I think seeing customary land tenure in the eyes of statutory law is what has proved challenging. And Ben has been highlighting that there's need to come up with specific strategies that are practical and actionable that can actually help with the process. Yes, we need the law, but then we do not have to constantly see the customary land tenure through it. Then there's also lack of understanding of the politics of customary law, which Ben was constantly talking about, and there's definitely possible abuse. And I mentioned it's exacerbated also by pieces of legislation. And there's power struggles, abuse imbalances, and politics at community level that have to be taken into consideration, even when the laws are being enacted. And there's definitely key, I think, examples that have been given already. Then the statutory legal system in its nature regarding interpretation of laws is constantly anchored on rules, so which are either aimed to uphold the law in its plain and ordinary sense, even in instances where it is illogical. And if you apply that to customary land tenure or customary systems, you find that it proves to be a challenge. And other rules are also aimed to investigate whether the intentions of Parliament is conveyed in the legislative provision and investigate gaps and apply remedies to the ambiguities of laws. And we see that as well, I think, prevalent. And another approach, of course, is for the Parliament to ensure that their intention is constantly effective. So if you do this to customary land tenure, you find that's where we have the problem. So I will end here because of time, and I will just invite any questions. Thank you so much.
Thank you so much, Dimuna, for those rich contributions, especially under the time pressure, which is unfortunate. We are now going to go to the physical venues for 2 questions each before we have responses from our panelists. And given the limited time, I really encourage our panelists to be scrolling through the rich chats that are being put up as you listen to the questions from the venues. I'm not sure which venue we're going to first. It looks like it's Josie.
Thank you. My name is Emily Charlie. I resided in Dwani village, which is on tribal land. Thanks for the presentation. Thanks for giving us that insight and highlighted all the situations that we are and what we can do, especially to Zenande and Ndate Ben. What is the best model of security of tenure at this current situation? I have struggled to get transfer of inheritance rights, transfer of the property and land that my mom left that I should inherit. I went to the tribal office with my two brothers, as they say it's custom that I should come with my brothers. And my brothers said, no, in my family, when mom says it goes to Emily, we agree we can sign. Instead, they gave me a letter written, you can stay there as long as you want. I don't understand that letter from 2015. Then the last one is that we grouped ourselves as women farmers, and we said we want land. And when we went to the tribal office, they gave us a paper that only says you can have user rights on that land. So after maybe we have harvested, anybody can come and take the land over. So is it protecting us, this system? Thank you.
Thank you, Chair. I'm Billy Marsha here in Johannesburg. Learning from the presentation by Professor Ben Carsons that we must have a tenure reform from below. The question is simple. Because of our situation in South Africa, whereby we have elected the government as the people ourselves, and then the same government is turned against the people, how should we then revolt against it? Because the hopes and aspirations of our people are in the same government. It will be very tricky for us to start a new movement, unless if you can provide some possible solutions. Thank you very much.
Thank you, Emily and Ntate Billy. Are we going to Durban or East London now?
Durban is ready. We only have one person to ask a question, so we'll donate the other to Johannesburg.
Siyabonga, Durban. We'll take that for our presenters. Joburg, you don't get another one. Okay, over to Durban.
Good morning, all. My name is Lerato. I'm from South Coast, and I was Tate Chief. I hear that it's a Ben. Yes, Ben said we have to get a big organization in here in our communities. I think our communities must be together so that we can get this big organization. I want to know now, how can we do that? Or else the lawyers can help us to open this big organization. If they can help us to open this organization, I think in our communities, it will help us to do things. We will have the voice to go to our traditional leaders because we will have that organization. And we will also going to get a very big support. Thank you.
Thank you very much. Now East London.
Thank you so very much. My name is Monolisi Jende from the outskirts of the Eastern Cape. Mine is a comment, not a question as such. We tend to lament over and over again. Among us, we are the loyalists of the current government. Why don't we unseat? We got all power to unseat the current government. We got all power to unseat the current government. We lament and lament over and again. The next thing, we go and vote for this same oppressor. How do we foresee our future for our next generation? Let us unseat this current government. That is the only solution. I thank you.
Thank you. I am Andiles Shuba from Leu. I would be very much worried if I could leave this conference without raising this, which I would like to raise, about dispossession, land dispossession. You know, I have noticed it during the process of this conference that the land dispossessions that we are talking about, they occur in various places, in various forms. But in our place, especially at it is a little different. It occurs very much and is continuing even now, but differently from the forms that I have listened to here. In our case, the same land dispossession occurs, but in the form of a human settlement, where the three phases of governments, the three governments, the apartheid government, the Ciskai government, and the current ANC government, they are settling people or communities from their places. They are taken to our own land and they are settled there. And we lose a lot of land because of that. And the second one, it occurs in the form of the game reserves. Our land is being sold to the overseas countries so that they establish their game reserves. I remember recently, maybe about a year or so ago, they were selling, or they advertised 6 big farms there. They were selling them to the overseas countries, but because the advert was available in the papers, I took the form and also applied for those 6 farms. I was called by their lawyers in Queenstown. They asked me, but do you have the money to buy the 6 farms? I said, no, yes, I've got it. They said, these are billions. I said, it's okay, I will have them. Give me the 6 farms. Ngelo xesha ndandingenayo, sorry, imoto yami yayingenazitayas, ndingakwazi uyawufika down. They just ended there. They did not give me further. Okay. Thank you.
Nkosi Kakulu, East London. Okay, so we are looking like we can be one of the first panels to actually finish on time, but that means I can give 2 minutes to each of the presenters, and then I'll just close off with the last bit of housekeeping. So Zenande, 2 minutes.
Thanks, Johan. I'll be really quick. I mean, so mainly, like, I think what you're describing is exactly the situation that we're talking about. I think has sort of come up in sort of probably most of the presentations and like in what we were dealing with there, where people aren't given their rights and they're not protected, and it's not very clear how those rights can be protected. And that the legislative framework that exists right now doesn't actually give people the rights that they need to be given, and they give people no security over their land. And again, the sort of the talking about the gaps in sort of the laws that are being passed, and also just really what Ben has highlighted in the need for needing different approaches to dealing with these gaps. We're dealing with the issues that we're trying to have responses to, that doesn't just rely on hoping that the state will give people what they're entitled to and give them the protections that they're entitled to. So I mean, yes, exactly what you're saying, people's rights aren't protected. And really, we need to be starting to think of different ways of approaching those gaps and approaching those issues that doesn't rely on thinking that the state is going to do its job. And then, sort of, I mean, I'm just going to jump to Monabisi's comment around sort of unseating the current government. I think it's really disconcerting that the immediate response really is to laugh at that idea, to laugh at the idea of completely changing sort of the context in which we're operating in. So I think it's like the last point I think I'll make is really needing to have just much greater imagination of what's possible and not thinking that the status quo is really all we have and sort of all we have to deal with. It is possible to think about what it looks like not to have the ANC as the ruling party, and to think about how we can think about achieving that, and to think about what it is that we're trying to achieve in that context, and having the imagination of what is it that what country and what is the South Africa that we're trying to build, and what is this world that we're trying to build, and having so much more confidence in our own abilities, and really being and having and sort of being brave in sort of imagining the kind of world and society that we want to bring, and really seeing that we're able to achieve that, and not thinking that the situation that we're in right now is the only possible situation that we're in, and that we can unseat the ANC if that is the most immediate way in which we can protect ourselves, and thinking about how do we do that and what it is that we're trying to achieve by doing that. Thanks.
Thank you so much, Zenande. Ben, 2 minutes.
I think the way forward is to build on the experience of the ARD, which manages to work with activists in very particular circumstances, but also link up those local situations through provincial coordinating forums. I just think that ARD needs to and can actually grow itself to being a truly large, significant player if it takes on the question of scale. I think that's going to have to involve different organizational models. I think we need membership models, for example. But I think the precedent, I think we have experience to build on. Another experience we should draw lessons from is the democratic trade union movement of the 70s and 80s, which actually was a key force in unseating apartheid. This was a bottom-up movement with trained lawyers and activists supporting worker-led struggles. It was lost in the 1990s. The trade union movement lost its way. As soon as the organizers start to be employed by companies, you've lost your way. If officials start to depend on donor funds rather than members' subscription fees, you've lost your way. But in the 70s and 80s, the trade union movement provides very important, powerful lessons about how to build power from below. What this involves, and why lawyers and researchers are important, each local situation is complex. It needs to be understood on its own terms. If you're going to shift the balance of power in, for example, the places where platinum mining is taking place, your enemies are very powerful. You have to think very carefully about how to do that. You have to use the law to win a local struggle, but you also have to be contributing and being supported by a larger movement. It's taking on both aspects, the complexity and particularity of local struggles and making sure that you win them, plus building alliances, plus bringing to bear questions of law. This is a much more ambitious initiative than simply trying to convince a democratic government to adopt the right policies and the right laws. And I'm not sure that we're well equipped to do so. But we have to rise to this challenge, or we're going to have to kiss goodbye to these dreams and aspirations. Thank you.
Thank you, Ben. Damuna, close us up with 2 minutes.
Okay. All right. Thank you, Johan, and thank you, Ben and Zenande. So my key, I think, concluding remarks are definitely, I think, stuff that we've already talked about. I think the conference has, in short, has wrapped up quite a lot, and it's also been wrapped up by Ben's discussion. But of course, there's definitely need to look into the social practicality of even the strategies or interventions that we're going to we want to venture in. Like Ben has been highlighting to us that we need to be a bit more practical. We need to be a bit more action oriented, and this is more like being proactive. But of course, considering the social practicality, the social politics that are there, as well as the political politics within these systems. And I think those are my, my key concluding remarks in terms of moving forward.
Thank you so much to our incredible panelists and to this group. I'm so inspired and moved by what we've been able to cover in this session, both by the panelists and by the people engaging from the venues, as well as this incredibly rich conversation that's happening in the chat, which I really encourage you all to go through if you haven't already. So we are closing off on time. Please be back by 10:30, where we'll start 2 parallel sessions in room 4A, free, prior, and informed consent in theory and practice. What is the next frontier for struggle? And room 4B, the interface between land tenure security and land administration. Thank you so much and keep well, everyone.
Good afternoon, everyone. We have reached the last bit of our program. We are now at the closing plenary, and I'd like to welcome those who are only joining us now virtually. And just a gentle reminder to please switch off your cameras, except those at the venues, and please place yourselves on mute. And just to recap as a start, the purpose of this conference was to bring in activists, academics, and those from the civil society to document and expose the current threats to tenure security. We aimed to examine the place of customary law in the constitutional era and the interface between customary and common law land rights. But most importantly, we wanted to think about strategies to build resistance, be it mobilization, litigation, all which can inform a proactive development of policies. Now, with that said, we have invited 3 speakers to reflect on the conference, but also to share their perspectives about possible strategies as well as a way forward. And so in the speakers, first will be Usindiso Mnisi-Wicks. She is an associate professor of law and society in the School for Global Inclusion and Social Development at the University of Massachusetts in Boston. And also she is an adjunct associate professor in public law at the University of Cape Town. She previously worked in the Rural Women's Action Research Program at UCT, combining research, advocacy, and policy work on women, property, governance, dispute management, and participation under customary law and the South African Constitution. Sindiso will speak for about 15 minutes, and then we will pause for 5 minutes for the translation in venues. The platform is yours, Sindiso.
Thank you so very much for that generous introduction. So I'm very glad to be with you all, although I'm very sorry that I wasn't able to attend much of the conference. I'm very glad to be able to share some reflections and thoughts with you. So I wanted to start by just sort of summarizing some of the themes that have stood out to me from the conference. And I guess the sort of main one, and part of it is coming from my own reflections and thoughts in the last few years. I guess the main one is really the failed impact of the transformative vision of the Constitution when it comes to thinking about land and rural spaces, primarily because of the failure of the transformative constitutional vision of our democracy to be implemented in the space of traditional leadership and the powers that are given to traditional leaders. And so these very disproportionate powers have these significant distorting effects on the way in which our communities are governed, as well as the ways in which our communities are able to enjoy land. And so I guess I would make particular reference to the ways in which land is a primary site of contestation over traditional leaders' power and their unaccountability, because it tends to be unaccountability rather than accountability. The second thing, I guess, is how traditional leaders use that power and unaccountability that they are afforded by our government in order to stand in the way of democratic, whether you mean liberal democratic or vernacular democratic, as well as economic, and by that I mean whether capitalist or subsistence forms of progress. Another thing is that the citizenship implications of, rural people, and among them, I guess, especially women, being subjected to traditional leadership without consultation or choice and being dispossessed of their informal, whether you want to call them informal or communal land rights, without consultation or consent are actually really tremendous. And then the direct tie between the impoverished systems of democracy in rural areas and the continued and deepening impoverishment of people who are already vulnerable who live in those rural areas. In the opening panel, I spoke about the ways that Ubuntu or Butu is key as the grounding for the future of customary land rights in South Africa. And I want to dig into that more in these brief remarks, specifically digging into what I think that means as a way of tying together so many important points that have been raised by colleagues during this conference. And specifically the points I want to draw attention to are the inherent human dignity of our peoples, the sovereignty of collective groups of people, regardless of whether they have a traditional leader or not, the right to choose their leadership structures and the people who occupy or populate those positions, as well as the right to remove them when necessary. The spiritual significance and importance of the land, as well as what is buried in the land, whether we're talking about minerals or we're talking about our ancestors, remains. The fact that bottom-up arrangements have legitimacy and should not depend on formal government structures and laws for them to have that legitimacy in law. The fact that when these rights that I've mentioned are not given due regard, not given respect and protection, that which is a failure to appreciate the profound distinction that is described by a Native American scholar by the name of Sandy Grande as, quote, the difference between subjectivities produced in and through relationship to land and those produced under and through significations of property. In other words, the sort of economic valuation of property within a system of economics that generally generates precarity as a constant state of being. This disregard, this disrespect, this lack of protection of these rights is tantamount to dispossession. In short, I want to make the case that the histories of violent land dispossession of Indigenous Africans, South Africans on one hand, and the denial of the legitimacy of their normative and governance arrangements on the other hand, cannot be separated from one another. The undoing of, both plunderous doctrines of terra nullius, which rendered Indigenous Africans, quote unquote, the natives, people without land, and lex nullius, which rendered those same people without law, in terms of which they could legitimately defend their land, right? Because if you didn't have law, then you couldn't defend the land because you didn't have any rights. And the effects of this undoing of these two doctrines of terra nullius the effects of terra nullius and lex nullius, in order to be undone, require that we pay close attention to the ways in which they are mutually constitutive, right? The ways in which they depend on one another. So you cannot actually deal with the land issue without dealing with the law issue. And yet South Africa's government, and I would go so far as to say South Africa's so-called transformative constitutionalism as a whole, has not adequately confronted or addressed either of these elements and concerns. And furthermore, the failure to recognize that these realities of terra nullius and lex nullius being the foundations of South Africa's sort of colonial apartheid arrangements and therefore being deeply entwined is itself a failing of South Africa's democratic aspirations. And I would go so far as to say that's because you cannot transform South Africa's land away from its embodied colonial apartheid legacy unless you transform South Africa's law away from the predominantly colonial apartheid basis of its assumptions and arrangements. And so I want to make the strong claim that the operative theories of law and land, much like the dehumanizing histories in which they are founded and the colonial logics on which they are premised, are a fallacy, if only because they are established on a false view of the majority of South Africa's peoples. In other words, I think the fundamental questions with which we are faced aren't necessarily ones of land or law, but rather of personhood. And these questions require us to, I would argue, imagine alternative modes. And the play on alternative is deliberate. So, the government, colonial and apartheid government sort of crafted this idea of the natives, and we need to envision an alternative version of the natives and imagine an alternative modes of social and material existence, as well as political participation. And
2 minutes, so 2 minutes.
Yeah. Okay, yeah. Thank you. This makes me turn to Mokgobe Ramos's work on Ubuntu, Butu, and really sort of breaking down what it is that is meant by this fundamental set of concepts as relates to our personhood and vernacular law and the entire value system that undergirds it. And I guess I would just say that the definition that South Africa has tended to lean on of Ubuntu as basically dignity, right? And using it in service of other protected rights, such as equality, is rather impoverished, actually. And I want to argue that the importance of our government's understanding and fully embracing the vernacular law principles of personhood as a foundation for all other legal principles, which are necessarily built upon it, is crucial. And indeed, ultimately, our only hope for change, because it is the only place in which all of the themes that I pulled out from the many excellent presentations at this conference actually find resolution and are ultimately reconciled. And so, in the end, I guess I would say it's the focusing on personhood, focusing on our understanding of personhood and grounding it in our vernacular understanding of personhood and concepts, Ubuntu, Butu, in the robust sense, in the full sense. That's the only means by which we can find our way out of what Joel Mudiri has referred to as constitutional unknowing, and find our way into what Tsepo Madlingozi has called homotufatsa, which he translates as rehumanization. And with this, I think that for me, the key sort of legislative intervention is to understand that the TKLA's disestablishment of community authorities is a profound infringement and is actually in many ways the sort of representation, key representation of the ways in which the relationship between land and law are activated within our current democracy, and our failure to appreciate them as mutually constitutive and therefore mutually destructive if they're not attended to. Thank you very much for the opportunity to share these reflections.
Thank you so much, Cindy, for that insightful presentation. I'll just allow for a pause for us to be able to translate to the different venues.
Professor Cindy so Munisi una le ka go ka susubanya mathata na le ngona ka melao e leng teng mo Afrika Borwa country ya rona re ratang o tlhalose ka mokgwa molaotheo wa rona e le gore o re feitse ka teng a ba tlhalosa gore go na le matsapa a gore na re pila-pila re ipusa yang ko magaeng o tlhalose gape gore mara puso selegae ke eng aba feletsa bua ka mathata gore na re tlheng batho bomme ba gatelelwa gore ba tshwantse ba nne ka motlase ga magosi ke mathata le nteng a tlhabisitseng ebile o bua ka mathata a gore tsamaiso ya kgatelelo le go aroganya batho ke dilo tse e le gore ntse di tswelela pele go tswa kwa logo go butla ga jaana ke mathata a ntse a le teng jaanong yana mme puso ya rona ga ne ba ntse koo ka nako e le nako ya colonialism le apartheid ba ne ba le leitlho le leng tšhotšho ba na le ponele pelo ya gore ga ba tsena mo pusong ba ile go fetolwa yang system e re kry-ileng e tsamaya e le teng mme erile ga ba tsena mo pusong ba tsweletse pele ka system eo ga go sepe se se phetegileng ba gaetso a ke ra bona so seng kgone ditshwanelo tsa batho di gatelelwa ga gona se se botoka se ba se dirang go ka dira gore ditshwanelo tsa batho di nne botoka mme ntse ba tsweletse pele ka go tlholetsa ba gatelela batho mme o buile gape le ka ntlha ya ga mewa ya gore o ka seke wa tlosa mewa ya batho ba ba tlhokofetseng mo lefatsheng mewa ya batho bao ba ntse ba le teng ke badimo ra ba tlhompha ke tsamaiso e ntse re itse go tswa kwa lowe a ke ra gore ka seke ra e fetola mme o tlhalositse gape le ka go tlhoka tlhompho ya batho ba ba tshwereng mafatshe especially go tswa ko metseng selegae gore ga ba tlhomphi batho ba metseng selegae ba gataka kwa fela ya ka go ratiwa a ba tlhalosa mathata gore le melao e leng teng e pila-pila e tshwanetseng ke be ya fetolwa e ba e tlisang e na le mathata o tlhalositse ka gore re di-natives ka nako e le ne re bidiwa di-natives ka nako e la colonialism seng kgone ba feleditse ba dira dilo tse le ba di rata melao e le gore e suta bona ga e sute rona mme ko bofelong ba fitlhetse gore re na le tsamaiso e re na leng yona ya go ya ka dingwao tsa rona tsa go farogana tsa botho o bile ka botho gore botho ubuntu ga boyo mo bathong ba puso ya rona kore ka mokgwa ba leng selege ka teng batho bao immediately ga ba ka ba se kokomana setulo seo motho a teng ebile wa lebala gore go fa o dirisana le botho ba gage ga botho le bonna teng wa lebala le ena ke motho o feletsa se sa lebetse mme o tlhalosa gore puso ya rona e tshwanetse e fetole mokgwa e diragatsang dilo ka teng ko bofelelong ke se ba a tlhalositseng mme ko bofelelong ko rona batho re tshwanetse re emeng ka motho gore dilo tsana di tsamaye sentle ke a leboga.
It seems that Devin, okay, I think they're done with their translation. I was following the chat as well on our chat section, and Professor Cousins, having worked in this sort of struggle for a long time, is saying, I'm becoming tired of our tendency to relentlessly reiterate idealistic normative statements. What are we going to do about it? And so Cindy is saying that one thing that could be done is to have legislative intervention which take cognizance of principles of personhood. And to move forward, I'd like to bring to the fore our second speaker, Usis Kony. She really needs no introduction. She's very well known. She's the national coordinator of the Alliance for Rural Democracy and also an MPhil student at the Institute for Poverty, Land and Agrarian Studies. Usis Kony, you've got about 5 minutes. Please take over.
All right. Thank you. For me, it is a privilege to be recognized to be a person wrapping up this very complex discussion, complicated, complex, technical discussion. I would just reiterate what the speakers from the communities from the venues have been saying as a reaction to what the presenters has been saying. I think the first day we started by defining a problem. So all the presentation were trying to say, what is a problem? What are we crying about? And why is it a problem? I think this process of problem articulation is very powerful and has to start at the village level. So often at time, we rally people to meetings, we rally people to workshops, but they don't even know they don't understand what is the problem. Why are we here every time and yet we are not getting to where we are supposed to go? So I think it is a challenge that we all of us has to take and make sure that it happens at the local level. So the first they talked about a lot about customary law, whether the difference between custom and customary law, traditional leadership institution and the society, and who should own and monitor customary law. Whether we want it codified, given the fact that it's a living law, it's a rotational law, and also whether we want it to be that way, to be a fluid law which is rotational, or we want it to be codified. The answers lies with the people whose this law are going to affect. And the most important thing that came up was the definitions of the community, because all those definitions are the cause, in fact, the root cause of why we cannot unite as community, why we cannot agree. And the invisible value of the land, which is sometimes, swept up under carpet, that people can move every time, that people can be compensated and be relocated, simply as that. Even graves can be relocated without looking at that. But all this is it's a collective problem statement for academics, for lawyers, and for activists. But also, most importantly, it must be for the society at large. But as these three groups, we all have our different interests and our different strategies. What do we want to do out of that? So I think with the immediate action is that we need access to attendance registers of all the venues, and to make sure that we can broaden or swarm up our WhatsApp groups for easy implementation and a communication strategy. So we need to disseminate the information we had there. How do we do it? How do we do it in a simplified manner, and making it simple for a layman to understand the technical language that is being written here? So for us to publicize content, I think we need fact sheets, we need resource guides, simple booklets that we can make sure that the people can read it and then understand it and act on it and agree on our coordinated action. So we need to have a reaction in terms of what is happening around us. There is an expropriation bill which is going to be debated this month. Is the expropriation bill asserting what we want to see in the law, the articulations that was made in this conference, things like making sure that IPIRA cut across, and making sure that when we do expropriation bill, we make sure that the land rights of our people, the customary land rights of our people are protected. Remember, if expropriation bill is passed, it's not gonna be passed for private farms only. It is one law, one South Africa, all the people of South Africa. So how do we make sure that we protect the land that is being acquired through land reform, restitution, and the communal land that is being expropriated already by the traditional leaders colliding with companies? So how do we make sure that our voices as this conference are going to infiltrate those processes of legislation? The Communal Land Tenure Bill, which is in front of Parliament, and the TKLA mobilization. Remember our campaign to stop the Bantustans, because when land laws are made, the land that is the former homelands is targeted. So the land that we knew that we were dumped in because it was considered dry, it is now being encroached, it is being grabbed. So how do we make sure that laws that are made for traditional leadership and for any institution are not only limited to boundaries of the former homeland. We voted for a democratic South Africa, which is one South Africa, one for all. So we need to make sure that whether it's a law or whether a tribal court law, a traditional leadership law, or anything which is dealing with governance, land and mining, has to be laws that are applicable to the rest of the country, not only to black people who were dumped into the dry land in the former Bantu stand. So action at local level needs to be visible. We need to start being visible. Let's go and mobilize others. So if you are representative in this conference, we challenge you to make sure that you invite us or you video yourself on the community meeting. We also need to do capacity building on information gathering. People need to know their boundaries. We need to go and collect the maps of the land we are crying about. People don't even know what is the land. You say we're fighting for our land rights. Which land rights? Where are they? So let's go to the archives. Let's start doing our jobs as people who are activists and be active. Know our territory. So when we talk about customary land, we know which land are we talking about. So a uniting factor is identification of a problem statement. But a uniting factor is also mobilizing across sectors. So in your community, if you work with all other organizations that we don't know of, please map them out. Let us know where they are so that we can implement a united strategy going forward and implement what Professor Cousins has just said. Let's organize across sectors, trade unions, whatever. But probably we need to find a new way of organizing as well. We're not going to be able to organize the way the UDF has organized, the way the Women's Coalition has organized. But in the new era of technology, what are strategies that we can do? And we need capacity building of our activists to make sure that they use social media, they tweet, they can make their problems in the village known to the world through the social media. So I think I want to end up there so that I don't waste your time, Mr. Chairperson. Thank you very much.
Thank you a lot, Connie, for that insightful reflection. I'd like to just pause and for us to be able to translate to the different venues.
Constance Mahali, National Chairperson of Alliance for Rural Democracy. Unaso sobanya lena malatia mararu antse re le teng fana. O tlhalose gore re tshwantse re bitse dikopano ko metseng ya rena ba gaetso. Se ra ga re tswa fa re bona ko morago. Re be re nna mo di ntung tsa rona mo mefutong. Ka re fa re metse batho tshwantse re boele ko batho re bitse dikgotakote re fane ka di report gore go dira ntse re bua ka emfa. O tlhalose gore molao o wa rona wa selegae re tshwantse re o lebelele ka leitlho le leng tšotšo se ke ra o tlogela fela ba nyelela a ba bua gore re buile gape ka gore nna ga re bua ka morafe re bua ka eng tshwantse re itlhaloganye gore morafe ke eng o buile gape le ka mathata a gore re tshwantse re itlhaloganye re le diagente re le bakgaratlhi ga mmogo re le di-academic gore ke eng se re se batlang ke eng se re batlang go se fitlhelela sa tlhalositseng a ba bua gore a re diriseng metsetseleko ya bo di-4th industrial resolution go tshwana ka le di-WhatsApp group tse le di tshwereng tse di-Facebook yalo yalo gore re kgone gore re nguna-ngune bagaetso re kgone go bua a ke ra bona ka mathata a gore re dimetse se re se dirang fela gore motho o ntse a picture ka gore mpone ke ipila yang a re se ke ra dira yalo a re tsene mo puisanong re bueng ka ga mathata a re na leng yona yaka re le batho ba ba tswang mo di-committing o tlhalositse gape ka matsapa a expropriation bill gore bili ke eo e fo pele ga rona and bili re buang ka yona ke bili le gore ko bofelong ga puso e ka e diragatsa re wa tselwa mafatshe rona ba re tswang ko metseng selegaeng yaka go tswa kwa lowe ba ba tshwereng di-title deed mafatshe a bona ga tseiwe go tseiwa mafatshe a rona so bili e lebeletse rona puso rona ba tlotla gape mo go rona ba fitlhe ba nna theona mafatshe a re a tshotseng yaka ntse ba tlwaetse a ke re go tshamekola mo rona re di maumao rona ba gaetso ke ona mathata ga re lwe le ditokelo tsa rona mme a ba tlhalotsa a re emeleleng yaka batho ba ba tswang metseng selegaeng re emeleleng ditokelo tsa rona re se ke ra emela puso e tshameka tsa rona o tlhalositse ka molao wa TKLA gore le ona o na le matsapa re tshwanetse re lebele ka letlolo e ntšotšo ka re ko tsa thata tsa rona o di fa magosi so go ra re go ntse go tswelela pele go a phuphuriwa bagaetsho ke sa se buang mme o tlhalositse gore re tshwanetse re tsamaye re go mobilize ke se tshwanetse re se direng go mobilize ke go bua le bagaetsho le mekgatlo e mengwe e leng teng ko metseng ya rona se ke ra itebela ga o na le mekgatlo e leng teng ka fale a re lebele mekgatlo re buisane le ona re dire mmogo ke ra bona re se ke ra dira dilo tse di dirwa ke bo UDF ka nako tseo go ne go sena dilo tsa go tshwanakana le metseletsele ya go bua ka di-cellphone metseletsele ya go tsena mo di-social media yalo le yalo so a re tshwanetse re ipope ko bofelong re itse gore bereka bjang a ba tlhalosa go bofelong gore re tshwanetse re tsamaye gape re go batla mebepe ko di-archives ko bo ditse office kwane re itse gore ga o bua ka lefatshe la gago o bo le itse le simolola kae le felela kae se ke wa bua ka lefatshe o sa itse lefatshe le simolola kae le tswa ko kae ga re go botsa ka lefatshe la kwaeno ga o na le mmepe o mowane o bontshang gore mmepe o ke mmepe wa Goedgevonden Goedgevonden e rekilwe leng e simolola kae felela ko kae seng gone batho ba nathola mafatshe a rona ka di-piece yalo le yalo so a re ipopeng bagaetso ntwa e tswelele pele aluta.
Thank you for that. We just had our Sconi speaking about that we need to improve our communication strategies. We have to share fact sheets, guides, and that we have to have coordinated action and mobilizing across centers, and that we also have to take advantage of the use of modern technology as we organize and as we mobilize. And she also said, for example, with the upcoming expropriation bill, we need to ensure that communities are participating. But in our chat box, we have Rodrigo and Bulelani actually speaking to that. There needs to be a differentiation between participation as well as consultation, because the two are different. Participation ensures that the process is much more meaningful, and it actually includes communities in participating in collective or political binding decisions. I'd like to move on to the third and final speaker of the day, Professor Nomboni Sugasa. She is a feminist, a researcher, writer, a political analyst, and an activist whose work focuses on land, gender, politics, cultural issues, and women in South African history. Her unique contribution is in straddling the academic, the policy, community activism, and public worlds in ways that enriches the discourse and promotes an understanding, as well as brings about social justice. With that said, I'd like to hand it over to you, Prof.
Since the conference, the summit since the summit in May, the Communal Land Tenure Summit in May, which was organized by the Department of Agriculture and Land and Rural Development, together with COCTA and Justice Department and the Presidency. I have been thinking a bit about where exactly are we in relation to the Communal Land Tenure Bill? What are the key challenges and what are the issues that we're going to be facing ahead? The first issue ties quite a lot with what people have been talking about. I think in the first instance, we have to acknowledge that the times that we're living in terms of the nature of the crisis in South Africa, is like no other crisis that we have faced, certainly in the last 5 years. That is not to say that the Zuma years were better or we're able to work with them, but that is to say that the accumulation of the problems that were created in that 9 years, on top of the lack of policy clarity of the years preceding, and the kind of crisis that we're in today, has put us in a situation that I think we have not fully or adequately understood, the depth of the crisis. So it's similar to what Ben Cousins raised earlier, but I think that at another level, it's an incredibly poor state in terms of thinking. It's a state that has become wasteland. There are no ideas, no new ideas that are going to come out of the state. They are clinging on to whatever ideas they had before, which in any case were inappropriate, but also were resulting in policies and legislation that were a mismatch between what they want to achieve, they say they want to achieve, and what they actually are doing. The second aspect of this crisis, as I see it, is the shrinking, in my view, of the space that we have been using very effectively, which was discussed in this conference, that is litigation. There is no doubt that in the last 15 years especially, there's been incredibly powerful ways in which the Constitutional Court and other courts have provided clarity on the kind of legislation that would be in line with what the Constitution promises in terms of Section 25(6). There have been further illustration of how this can be understood in various judgments, including Baleni and many others, where the notion of consultation, the notion of talking to people is given further and further clarity, so that we can fully understand that there is no shortcut to what is required in Section 25(6), which says a community or person. I do think that that space is becoming more and more limited because what we have seen is government that simply does not respond to court rulings, simply does not take them seriously, does not implement what it is supposed to implement, and also has taken, obviously, to defending when they are cited in cases, to defending this alongside conglomerates and others. So even though we may get the judgments that we need and we may get the clarification that we need from the Constitution, there's a clear culture that is developing, which is basically disregard for that or simply appealing. So we have a situation where taxpayers' money of citizens is being used against citizens and to repress any action that we may have to give meaning or fuller meaning to the Constitution as it provides for these rights for us. I'm not saying we should abandon this, but I think that we should be mindful of that. But there's also, obviously, globally, it's becoming very clear that that space of constitutionalism, that space of asking constitutional judgments to breathe life to the provisions and the rights that are given in the Constitution, it is shrinking globally. Although in America, what the Supreme Court is doing, we may not think it applies directly to us, but I do think that our politicians do take cue from what they see to be happening globally. And I think that there's going to be more and more challenges to these as more right-wing politicians are on the rise. For example, Mogoeng, the former Chief Justice, and his brand of Christian right-wingism and all that, if they do come to office, we will see more and more challenges, even to this space that, to some extent, we have come to take for granted. I think that if we start with what I said about the poverty of imagination, the wasteland nature of government, maybe we should go back and say what colleagues have been saying. How do we understand the nature of the problem? How do we state the problem? I think, again, following the summit in May, I actually sat back and thought, okay, there's just the wrong-headedness and everything else that we know is a problem with how government has been approaching communal land tenure and the rights of people who live in traditional communities, or so-called traditional communities. But the summit in May made me pause and think about how we have come here. So in terms of way forward, here are things that I think we need to restate and to re-examine. First and foremost, there is no doubt, it became very clear to me at that summit, that there's no doubt that we are also experiencing the failure of articulating what a post-Bantustans, post-apartheid South Africa would look like. So starting from 1955, we have the Freedom Charter clearly stating that the land belongs to all who live in it, the country is for all of us. We have not really figured out how would this look for people who live in former homelands. At the summit, speaker after speaker, all the politicians started with Adam Cox said this, the 1913 Land Act and all of this, and they all echoed each other in terms of talking about the legacy of colonialism as they understand it and the legacy of apartheid. All the political principals, as well as the leader of CONRALESA, Chief Nyalala, when they spoke, it was as if the last 28 years have not existed. It was as if they were giving speeches at a land summit in 1994 or in 1995. There was no learning that they brought forward in terms of their policy making and all of that. Part of that is, I think, is that the ANC has never had a reckoning of what it would mean to have traditional leaders in a democratic South Africa. So when they all spoke, they spoke about the history of the ANC and the history of the ANC, which has always had traditional leaders, you know, from the founding fathers and all that. But they were silent about what really happened in mid-20th century. So whilst the traditional leaders were part of the formation of the ANC, and whilst they were part of the anti-colonial movements, there was certainly a change in the mid-20th century with the creation of the Bantustans, with the ascension, first and foremost, of the national government in 1948, and when they came with the strategy that would see leading towards the Bantustans. So those progressive traditional leaders who were out of the system, so the kind of traditional leaders that we had from then in the main were those who were doing the apartheid bidding, apartheid states bidding. So there's a silence about this in
3
government.
minutes.
How many minutes? Really? Okay, so there's a silence about this in ANC because they have never really thought about this. So unlike the conferences and conversations about the rights of minorities and the status of minorities, which were led by delegations that were led by people like Fanzil Slabat and others, we never, after there was a decision to start working with traditional leaders leading to the formulation of CONRALESA and all that, there was never a conversation about how would this be. The people who were campaigning for rights of minorities were able to influence this, and it's peppered throughout the constitution because they were coming from minorities that had power and minorities that had resources. So I think in the first instance, in this period of looking at where do we go from now, I think we need to restate the problem and put forward our own vision of what we think a democratic society would look like with traditional leaders. Secondly, I'm just finalizing. Secondly, I think in restating the problem, we have to put forward the nature of the problem as it is felt and experienced by people and do a comparative of how people lived under Bantustans and how they live now and see how that actually compares. And I think in doing that, we take the conversation beyond the laws and the bills. We take the conversation to the quality of life.
Prof, you on mute. Can you unmute, please?
I don't know, it's you muted me. Anyway, finally, I think that I agree with Ben Cousins that we need a much more engaged form of mobilization. We need a much more energetic and imaginative way of mobilization. I agree with Connie that we can use the tools that exist, social media, TikTok and all of that. But I think essentially, we need to have strategies that build social movements and that build political movements in a way that interfaces with people's real time and real experiences. Finally, if we state the problem as not just the problem of lawmaking or just the problem of policy, but essentially as a political problem, and we take it to the theater that is the political space, and yeah, use conference rooms, use research and all of this, but ultimately make it to be an issue for upcoming elections. A lot of speakers at the conference have spoken about coalitions and all that. The problem is that our conversation about coalitions in South Africa is truncated. We are not having a conversation of who is coalescing with whom, because all these political parties, if you look at them, including EFF and DA and all of them, there isn't really anything that they bring to the table in terms of communal land tenure that is beneficial, that actually breeds life and dynamism. I'm afraid we're going to have to do that ourselves. Thank you.
Thank you so much, Prof, for that insightful reflection. I'd like for us to pause for translation to the different venues.
Hello? Oh, okay. Thank you. Ke meno mbonisho kasane ke sepa ba le monna ntse ka go morago kadi una re tetse mabana na le rona una le ka lena go sosobanya dipuisano tsa rona mabapi le tshokolo ya mafatshe go simolla maloba ka di 17 go tla ka jana o tlhalotse re ukila a tselela summit ene tshwere ko Bishuti go Boksburg ka May me a feletsa a tsa tshwetso a ka emenyana a ka ikakanyo mare sentlentle king se ne se buiwa fale o tlhalositse ka gore o kare space sa rona a kere pleke ya rona le mo yona e kete e nna e nyane gantsi ga re tla mo puisanong tsa dilo tsa mafatshe kona mathata so ya ngotlega pleke eo pele ne le tona me ano ka re ya ngotlega o ka re ga o tsana khatlego ka go bua ka dilo tsa mafatshe o buile gape le ka mathata gore dikgotlatshekelo di tsa ditshwetso ene ga di tsa ditshwetso di le ka gore di re tlhalefise gore ke eng se tshwanetse re se dire di re bula matlho mme ke te re itshela morito tsididi ga go tla mo bora dipolotiki tsa rona gore ba diragatse go fatlholla ga rona ke dikgotlatshekelo ga ba rate go diragatsa fatlhollo eo e ba e fileng mme o tlhalositse gape le ka section 25 subsection 6 ya constitution gore e bua ka yang ka go sireletsa batho ka mafatshe a bona a ba bua gore bora dipolotiki o tshwanetse ba ke ba tse maleba mo di-country tse ding yaka tse bo America le yalo gore ba tsamaisa yang dilo tsa bona ka gore ke te go na le matsapa mme a ba tlhalosa seng kgone re bona bo re mogweng le bona ga mmogo le dikereke ke tianong ba ikatametse anong go emela dilo tsa election ka makoko a bona ka re ba bona gore puso e tota ka boammaaruri ke a magodu ga gona ko re yang ko teng ke mathata mme sa bofelo o bila tlhalosa ka taba ya gore re Ben Cousins se la tlhalosa re tshwanetse re state ya ka re ke matlhale a na re fatlhosa ene gore tota go tswempa re tshwanetse re tse maleba mo se a na re fatlhosa ka sona o feletsa buile gape le ka mathata di political party tse dintsi tse re na leng tsona tse di na le matsapa ba gaetso ga gona sepe se ba se buang ga go tla ga dilo tsa mafatshe ba rotlhe ra itse gore leanong yana ke ra itse gore presidente tshwanetse o bua ka ga sone commission ga o bua ka sone commission o nna metlae fela se re sitseng yona dintwa fela gore o nna re lebelela television re utlwela batho ba bua ditsia badimo re sa itse ba ko kae ke mathata a leng teng ke se di-political part tse dintsi tse leng teng tse e leng gore ga ba buise se mosola ka tsona dilo tse di buang ka tsona tsa go sireletsa mafatshe specifically mafatshe a batho ba ba tswang ko metseselegaeng sa bona ba lebeletse dilo tsa di-expropriation bill tse gore re tseelwa mafatshe yang ke sena le ka gore a se sosobanye mme ke kgwetlho e re lebileng ke kgwetlho e le gore re tshwanetse re bone gore re bopagana yang re kgone gore re dirisane mmogo gore re feletse re lwantsha tsamaiso e bosule re e bonang ke lebogile.
Just to recap, Professor Gassa said that we need to restate the problem as a political. And I think my understanding is that we need to shift perhaps from thinking about the land problem or struggle as that which is a rural struggle, but frame it much more politically and nationally. And that's how we really can move forward, because the state as it is has an imagination that is captured, and in her sense of word, it suffers from the poverty of the imagination. And she has also prompted communities and us actually to think about what would a democracy look like without what would a democracy look like with traditional authority. So rethink this, but I'd say maybe also rethink of what would a democracy look like without traditional authority, because as Cindy has pointed out in her presentation, that we have a state which hasn't really thought about or adequately articulated the role of traditional authority in the post-apartheid era, and that's why we find ourselves in this position. And with that, I'd like to thank the three speakers and move on quickly to the three venues. I'd like to take two sort of comments in each venue or reflections on strategy or in a way forward. And so if we could just have those, who are brave enough to speak about how could we move forward, be it in a form of mobilization or even what is required of us researchers or practitioners and so forth. So if you could just keep these very brief, and when one venue is making its way to the podium, can we have others as well move so that we can be able to close in time at 1:30.
Aibo, okay. Ngiyathemba ukuthi wonke umuntu usaphila igama lami uNokwanda ngiyazi benginyamalela izolo kodwa ngiyabonga ukuthi we're still here. This is our final day. Before we knock off, I think izolo ngibhalile ku WhatsApp ukuthi bengicela abantu abayi4 basisize with summarizing ama plans moving forward. Bengicele uThemba Msiya, uMamdingeni, uYvonne Khusi and ubaba Magwaza. I think just ukuthi abantu basiphe just ideas, action plan with how do we move forward with what we've discussed kule land conference in the past 3 days. So if anybody has any ideas, ngizwile ngamahemhem ukuthi ubaba Khanyeza uthe we must develop a new language. Angithi so that's an innovative idea esingayikhuluma esingayibeka and some of the other things ukuthi we don't need law. I think Baba Khanyeza actually ukuphi ngoba uye nje obeka siphethela ama new ideas. Usikahambile? Oh okay, angazi ke ubani ongasicapture izinto Baba Khanyeza bekashiyo. Baba Magwaza ungakhona ukusipha idea nje of how to move forward. Ungenza la phambili baba.
Nokwanda, as ubaba aya phambili, I'd like to also say that kuzoba ne press conference on 2:30, and it would be helpful if the speakers can even basho ukuthi yini abangathanda ukuyibona reflected on this press statement or particularly articulated in the conference. But ngicela ukuthi babeka amagama masinya bangathatha isikhathi.
Okay. Baba bosozwile bathi singa overdose ngesikhathi. Just ukuncanyana.
Ngibingelele okugcina kodwa. Ebese kubona nekufanele ukuthi sikwenze masisuka lapha kufuneka siyo mobilize abantu emuva. Sibafundise ngamalungelo abo. Ngoba kahle kahle abantu abazi. Ngeke ngathola ukuthi kwezinye indawo bebevuma ama project bengazi ukuthi anomphumela muni ngokuzayo. Bethole sekuphakathi ukuthi azobadalela inkinga. Nalendlela yokusheshe sisayine singazi ukuthi sisayina ini. Kungcono ubuze kwamanye ama colleagues wakho ukuthi ngaphambi kokuthi kusayine uthi ngisabuyela emphakathini kanti usafuna ukubuza kuthina. Ukuthi nawo abantu befika la bethi bazokwenza iproject ethizeni singedlula kanjani lapha. Inkinga ke yobuholi bethu esiye sabona nje ukuthi uhulumeni uqale wabaholela imali abekade angahola amakhosi phambilini wabona ukuthi akwenele waseholela nezinduna kwase kuba ngobhoyi bakhe abasebenzisayo ukuthi basicindezele. Angazi ukuthi sizophuma kanjani lapho kubaholi bendabuko ngoba kusetshenziswa bona kuyimanje. Akukuningi sengibuyela emanzini.
Ngiyabonga baba. Can we have the next venue, please?
Good afternoon. My name is Mulatelo Mohale.
Ngiyabingelela.
Sorry, Durban, can you hold one moment, please? Joburg has just started speaking. Thank you.
Thank you. My name is Mulatelo Mohale. I just wanted to say two things around mobilization and strategy that can help us move forward. It's an unfamiliar strategy that I got to learn from the Indian social movement. So,
Code 14.
So the Indian social movement uses the strategy that they finance their action. It's not only one party that contribute financially, developing the content, and also shaping the debate in events like this. So it's all parties that come together from financial contribution and until the development of content and shaping the debate. Thank you.
Deben? Sorry. There is one more speaker in Joburg.
Okay, thank you. Good evening. Thank you for the conference. We, the activists from Northwest, Maditlokwa, I would like to say, please, we need advice and we need help, for we are the ones going on the ground. So we experiencing personal attacks, so it is very difficult for us to convince everyone, for we are attacked by people getting paid by mines. And we have to be considered a safety place also for us to engage with community. And then we have a challenge that other people are afraid to engage with us because we don't have powers to hire them. We don't have anything to give to them, like food parcels and so on. So to them, we cannot give them anything that will sustain them. So I would like to say we need help and we need everyone to come, every organization to be part and to be supported so that people will understand better what we are talking, because nowadays our community think with their stomach. They don't think with their mentality. So thank you so much.
Ngiyabingelela, igama lami ngudingeni wakamthimkhulu. Engakusho nje kusukela ngolwesibili sifika la i-workshop yethu ihambe kahle. enginginotisile ukuthi sonke njoba sikhona nje inkinga zethu ziyafana. Mina ke bengizothi indlela eyaphambili esicela ukuthi yenzakale kungaba ukuthi ama lawyers akhona phakathi kwethu akwazi ukusisiza einkingeni esithe sayiveza ukuze singathi next time masifika lapho uthola ukuthi inkinga zisafana. Endabeni yemthetho ke yona inkinga kakhulu njoba sekukhulunyiwe kakhulu ngayo. Umbono wami uthi endabeni yemthetho siyacela ukuthi uhulumeni before ashaye umthetho sicela ukuthi ehle lapha ezingeni eliphansi kubantu akhulume ngalemthetho siyibone ukuthi ikuphi lapha esilimaza khona ikuphi lapha esizakala khona ngayo. Ngingathi mhlambe yilokho nje endabeni ke yeyimayini ibe inkinga kakhulu kithi sonke. Siyacela ukuthi isikhathi esiningi uma befika laba bemthetho beyibheke nayo imithetho laba bama companies abafuna ukufaka imayini eindaweni zethu beyibheke imithetho le ephathelene nawo amamayini ukuthi ma benza into beyilandele nawo beyeka ukuthi bezenzele ngendlela yabo bengene emakhosini bengene enduneni bengakwazi ukuthi beconsult umphakathi ukuthi mawusondele. Ngingathi ilokho nje ngingakusho. Ngiyabonga.
Okay, molweni igama lami ngithabisa ngwakwamhlahlo. Mna way forward endizanayo apha we have to establish a task team in each and every region that will take our struggle forward. And then we also have to mobilize ourselves si-organizane so that sizokwazi ukwenza isangqe kuhulumende. Maybe we can even write a petition siyise kuhulumende simxelele ii-demands okanye izinto ingxaki zethu. Okay, I believe into ye-bills and policies zine-stages ezithile akuveli kuthiwe gqi kuthiwe zii-public hearings zii-bills. Uhulumende makasibandakanye in each and every stage esenzekayo xa ibill. Uba iqala kwi-white paper makasi-alert into yoba kukho i-white paper yebill ethile, i-green paper yebill ethile, makangaveli athi gqi sithi zii-public hearings. Okay, ubeko lo mba undityayo ke ngokwe-PTOs. Uhulumende makhe athi revisit umba we-PTOs ayeke ukucekela phansi ayeke ukucekela phansi umba we-PTOs khe zibe available ibhalwe phansi ibe semthethweni into yoba i-PTO ikhona is there ezilalini.
Molweni, ndinguNtombolundi ngwakazitha lapha e-Eastern Cape. Mna okwam ukubonga kukuba ke sibe lapha kule ndawo sonke simamele sikucekiswayo sizame into yoba sibekise sizame into yoba sikusebenzise oko kunako into yoba sikusisebenzele. Ndinento ke mna ke ethi kule nto yale mithetho siyamcela urhulumente wethu makangazi zodwa ukuba zizo ezifanele into yoba zibe sepalamente benze le mithetho naxa kusizwa kwi-public hearings thina sivinjwe ithuba loba singakhona. Siye sixasekeza public hearings ufumanise into yoba abona abantu baninzi ngabantu abaphuma ebukhosini because bona yonke into bayinikwe kwangexesha. Kodwa ke ndiye ndingabi nalo laloyiko loba asingethethi kuba sibambalwa. Loo nto niyithethayo uza kuyiva noba akazi ukuyisabela sikhuphe izimvo zethu. Ndiphinde ndithi mna singomama kuyabaluleka into yoba siphakame singoyiki ngoba kaloku ngo-1956 omama bakwazile uphakama laviwa ilizwi labo. So ngoku ingaba kwenzeka ntoni na ngoba kaloku siyoyika ukuthetha siphakame then asixhasani singomama kwakwi-communities zethu uthi uyithetha le nto ibalulekile ungaxhaswa ngoomama. So siyacela ke ngoku into yoba oomama mabasebenze beliqilima ekuthetheni. Enkosi.
Before I pause, I have to say that I've got a bit of a limitation when it comes to isiXhosa, so I cannot quite translate, particularly for the last speaker in East London. So if there's someone who can translate what Mama was saying in East London, the last speaker, in English, please do that. But I'd also like to just take 5 minutes after Ubaba East London. I can see standing up for the different venues to perhaps translate what they couldn't understand from the other venue before I move on to the last speaker in our session. Baba East London, you can carry on.
I took two things which were part of the submission by Umama. One is that there is a need for people to enforce their right in public participation. Seemingly, in many other public hearings that we hear in the Eastern Cape, a large number of people that were invited and attended were traditional leaders and lesser participation of communities. But having said so, she says that they haven't given up. They view the space, few as they are, to articulate their position. The second issue that she has raised is the participation of women, but in making a call that women need to be united to drive the issues and stand up. He actually says there's a lot of division within women in this sector. They need as women to stand up on the issues. I think that's truly the summary of the submission.
Can we just take a moment for the venues to translate what was said, particularly for those who might not understand, for instance, in Johannesburg, who might not understand isiXhosa?
Bakaiso, ko translate abela se remolatelo mahal na tlhalosa ba. Ka re ke sola se ke sebile. O buile fela ka gore yena o na bereka le mokgatlong wa maIndia. Se ba se dirang gore ba ntsha madi.
Joburg, you're on mute. Kindly unmute, please.
Kusian.
Hello, sir. We just missed your message right now. Would you mind just repeating yourself? Thank you.
Melody, Joburg was translating. There was no need for unmuting.
Thank you, Nalindi.
All right, thanks, Nalindi. May I please just invite the three speakers to just give us their concluding remarks, 30 seconds, quickly, in light of what has been said, but also of the discussion that we've had. I'll start with you, Professor Nisi Wick.
Sorry. Thank you for that. Apologies for the technical problem. Yeah, I guess I want to just appreciate all of the comments from everybody. Thank you for all of the really important proposals. I think the most important ones that sort of jump out at me are the reality of starting from the ground, that people are experiencing really, really challenging situations on the ground and need the support of institutions, of government, and of us as people who are working in these spaces and advocating alongside them to partner with them in ways that take seriously the reality of their circumstances and their precarity. I think the one thing that maybe I didn't get the opportunity to expound upon is, sorry, I thought I had more time than I actually did, was with respect to how, the ideas that I was trying to present relate to land in particular. And I guess for me, it sounds, I saw the comment from Professor Cousins, saying that in a sense, what I'm talking about is sort of esoteric. And I guess what I would argue is that it's actually not esoteric, because it's actually, when you are legislating, when government is legislating, and when they're making decisions about how to manage people's land rights, they're making decisions about people that they either see or people that they don't see, people that they actually appreciate as being, people who are actually equals, people who have full agency, and people who can actually, decide for themselves, or people who are basically just subjects, right? To quote Mahmoud Mamdani, people who are not effectively citizens. And so I guess what I would say is that, essentially, when we understand Ubuntu not just as a concept of personhood, but as a concept of something a concept that takes seriously people's connectedness and their relationality and their mutuality, then you stop seeing traditional leaders as being, authorities that get to make decisions from the top, but you actually start to see that, the idea of communities being their own stewards, being the ones who get to make decisions for themselves, is actually integral to even the traditional leader's existence, right? And so I suppose, in a sense, I think that to Sisnomboniso's very important and I think very appropriate comments about recognizing that there's a poverty of imagination. I think the poverty of imagination is primarily grounded in the fact that our imagination is being dominated by external ideas, in the sort of global political economy. Ideas like the fact, one of the comments that stood out to me from the conference was somebody saying, Uguti, we're told that our ancestors are standing in the way of development, right? What does that mean? Like that, what concept of development are we operationalizing in that situation? Essentially, if our imagination starts from where we are, from ourselves, from our actual positionality, then we are better positioned to actually come up with solutions that are appropriate to our circumstances. So I guess that's why I think that it's important that we start from a place of recognizing who the people are that we are responding to, whose needs we're responding to, whose relationship to the land we are trying to regulate. And ultimately, I think that what I was trying to say about the community authorities is that community authorities are actually in many ways the most representative way in which rural people in South Africa living under customary law sort of organize themselves. And it is this permission to organize ourselves as we see fit that is desirable, that is necessary. But in terms of the fact that the government, that we are not proposing a vision for an alternative reality with traditional authorities, I guess I would take issue with that, because I think we've been pushing an alternative vision all along that says that we are able to govern ourselves. Traditional leaders do not get to be the ones who take charge of our lives. So I guess I would leave it at that and make sure that other people have a chance to speak as well. Thank you very much.
No, thank you. Ask Connie.
I want to conclude this session by saying, Amandla, Amandla. I want you to repeat after me. Ne? The people together will never be defeated. Together will never be defeated. Again, people together will never be defeated. We need to stop the Bantustans. We need to stop the Bantustans. We shall stop the Bantustans. We shall stop the Bantustans. Thank you very much. I think taking from Sindiso and from Sisnomboniso around whose law, whose land, around domination of ideas and poverty of ideas. It is time to know that we are the ones we have been waiting for. Nobody, so people like, hey, we want lawyers, the lawyers must come. You are the lawyer of your own. You are the one you have been waiting for. I think if we reflect at what went wrong during the past 20 years, and we point fingers at government, at companies, at white people, the other finger is pointing at us. all right? Let's go find the land. Let's go fight for the land. Let's go correct what went wrong with our customary law. But then let's not behave like the same people we are criticizing. Because the CPA chairpersons are behaving like the same people we are criticizing. They are behaving like the chiefs. So for me, it is not about an institution of traditional leaders or CPA or CPIs. It is about our own rules, our own land, and how we want to govern it. And it is about the people. And if it is about the people, I want to see pop-ups, popcorns in the villages. This is what I want to see. And I think we all have to point the finger at ourselves. We all have to take responsibility and move forward. I am very inspired. I don't know if the delegates feel the same way, even though I look so tired today, but I'm very inspired. Thank you very much, Chair.
Thank you, Auskoni. Prof, you can see how you've captured us with your idea of the poverty of the imagination. So please give us your last remarks.
In pattern, you forget. Thank you so much for this conference. I've really listened a lot, and I've enjoyed especially some of the issues that we don't normally talk about in these kinds of conferences. For me, the session that looked at the spiritual, cultural dimensions of land was very important, because we often talk and see land being seen only as a commodity. So that was very important. But how do we translate this into public discourse? And also public discourse that, in fact, is going to have meaningful impact on the politics and decision-making. I want to suggest three things very quickly. One, the steering committee, or whoever, the group that came together to do this conference, I would suggest that in writing the report, and especially looking at where we go, you have a committee that looks specifically at way forward. Where do we take the proposals that have come here? The first thing that would be, for me, important from that would be to pull together the proposals, that specific proposals that have come up. For example, when people suggested, and we've said this so many times before, that in the meantime, IPILRA can be upgraded and made permanent. So that's a very concrete proposal. So we pull what came out of the high-level panel, the Presidential Commission, and all these. We pull the proposals that we think can inform public debate on what should happen. Secondly, and I know that the folks at LARC and PLUS do this very well when they do the fact sheets and all that. So we need that kind of a document. The second proposal that I want to make, I'm not sure how you do it. I don't want to just say ARD does this, but I think you need a delegation, a committee of people that are going to move from this conference and go and meet key stakeholders in society, especially key stakeholders that we want to build bridges and alliances with. The trade union movement, the people who are in the social cluster at NEDLEC, organizations that work on climate change, organizations that work on poverty and land and all these things, so that we start building a community of people that is beyond ourselves. We look at Landless People's Movement, Abahlali, Basemjondolo, all these organizations, you have this delegation that goes to meet them, so that we have our perspectives on the organizations that we come from our academic training, from our villages, but we meet other people who work in other sectors. Fourthly, I think we have to start building more and more awareness at a global level. If we have, the issues with Jindal, the issues with, a whole range of mining communities, we take those issues would table them in international platforms, would write to international platforms that manage these organizations or that these organizations are part of, and say, this is what your organizations are doing. Fourthly, and I cannot emphasize this enough, I heard my sister Ukoni saying we cannot organize the way UDF did and so on. I don't think we should limit ourselves. I know it's a different time, and it takes a lot of resources, but I do think that we need to build towards one massive campaign that would kick this, where we have a national shutdown that focuses on communal land. Of course, if you have a national shutdown that focuses on communal land, it means nothing. But if you have a national shutdown and you highlight the issues that people are faced with post-COVID, hunger, exhaustion, unemployment, unresponsive state. How does unresponsive state look like today? What does it mean to have 9 years of state capture and have no resources for these kinds of issues that affect our communities? So we have come up with 5 things. We come from different communities, different cultures, and so on, but we do have common platforms, things that cut across all of us. We build those things into 5 maybe talking points, and then we flood the South African media and other places. So what it will mean is that we need to think beyond ourselves. 2, I saw a question there about researchers, about researchers. We figure out ways in which we can get some research assistance on simple things on how to build a campaign. Many of us are activists, we don't need that, but we might need a supplementary information on how to use social media effectively, how to do this, that, and the other. 3, we look at the way successful global worked, and I'm going to use the Green Belt movement in Kenya. I don't even know if it's an appropriate campaign to use, but I do know that they started grassroots, they worked at national, and they worked at international. So we need to start targeting these campaigns. Finally, we need to talk to Koi and the Sen. And we need to talk to the issues that they are raising. We need to talk to them as fellow people that we travel with in solidarity. So I'm saying the next 3 months, we could have a planning that pulls together all these things and what we are putting out there, and identify people that we want to be joined with in campaigns that we can work with. Thank you.
Thank you for that very thoughtful reflection on going forward, Professor Gasa. And I'd like to thank, all the 3 speakers for having taken your time to actually think through the conference, but all the proceedings of the conference, but also to lead us with the way forward. With that said, I've come to the end of the program, and I'd like to invite the Director of LAC, Mrs. Nulundi, to close for us. Thank you.
All right, let's try that again. My apologies. Hello to everybody, and apologies for that glitch. Bendisithi okwam kukubulala kuthiwa ke ngenxa yoba ndiye ndathetha isiXhosa ndicingelwe ivolume. I wanted to just offer a very short vote of thanks. My sincere thanks goes to one person in particular, and I'd actually like her to turn on her camera. Sian, are you there? There we go. Ladies and gentlemen, without CN, there would not have been a conference. CN is the conference coordinator, and all of you who participated in the conference would definitely have had contact and communication from CN. CN, I wanted to offer a sincere vote of thanks for the work that you did in pulling this conference together. Without your persistent, gentle, calm efforts and reminders, we really would not have been able to do any of what we've done over the last 3 days. And I really just wanted to acknowledge the incredibly large amount of work that you took on with generosity and with grace, and to really offer, if we can, a virtual round of applause for the work that you've done in pulling this off. Thank you so much, Sian. I then want to say a thank you to the organizing committee. As colleagues know, this conference was co-convened between LARC, PLAS, the LRC, the ARD, and SWAP. I wanted to acknowledge the colleagues who sat on the organizing committee with us, in particular from PLAS's side, Professor Ruth Hall, Dr. Pilanza Mchia, from the LRC, Ms. Valmin Vikram, and from SWAP, Dr. Dineos Kosana, from the ARD, Auskoni Mukhale and Sistepo Fogane, and from LARC side to acknowledge my colleagues Unokwanda Sihlali and Ustembiso Gombi. Thank you to all of you for the time that you contributed to the endless meetings and the energy that you always brought to those meetings and the commitment to tasks. I also would like to acknowledge the organizations themselves, as I say, PLAS, the LRC, SWAP, the ARD, and LARC. Not only did colleagues bring their organizational weight to the conference proceedings, but they also invested an immense amount of other forms of resources, and for that we are endlessly grateful. I want to acknowledge the UWC team who has been running the Zoom platform. To Melody, Hardy, Graham, thank you so much. Without you, again, we would have had no knowledge as to how to begin to even do something like this. For, again, your patience, for helping us with the technical glitches, and for guiding us through what was a completely new process for us. We extend sincere gratitude to the UWC team who ran the platform. I want to acknowledge some of the administrators in our organizations who also are unseen, but who did a lot of work in terms of booking venues, making sure that arrangements were made. I also particularly want to acknowledge the provincial coordinators who made it possible for the in-person venues to take place, the teams in East London, Gauteng, and in Durban. Again, without your efforts, without you doing the groundwork, there would have been no conference. We are incredibly grateful for all that you did to help us. I then would like to acknowledge all of the panel chairs and the panelists. Thank you so much for agreeing to serve in those roles. Thank you for your enthusiasm, your dedication, your willingness to participate. A conference really isn't a conference without participants and without presenters. So thank you for bringing your insights and knowledge and being willing to share that with all of us. And then I want to acknowledge some of the funders. I did acknowledge them at the beginning, but to take note that the conference was generously supported by a range of funders whose contributions we are grateful for. And finally, I'd like to thank everybody who attended, all of those who logged on for the last 3 days. Without you, again, the conference would not have been as successful as it has been. Thank you for bearing with us through the technical glitches and recognizing that we were learning as we went. Thank you too for all of the feedback, both positive and negative feedback. It really has helped us to shape the conference in ways that hopefully have improved the experience. And so we're incredibly grateful for all of that participation. Colleagues, although the conference itself formally ends, I think that the creative bottom-up work just begins. And so I hope that you all rest very well over the weekend. We will see you in the trenches on Monday. Ndizocela ke umhlabeli wam asifake kwingoma. Colleagues in Durban and Gauteng, we hope you'll join in the song. Can we unmute?